Ladies and gentlemen, welcome to the panel 3, European 3 session of today. Before I introduce my speakers, allow me to introduce myself a bit. My name is Jonathan Mock. I have been practicing in private clients litigation for by now 32 years. I am a solicitor advocate, which means I tend to go to court myself. Being a solicitor advocate, I need to know, obviously, everything a bit about the private client's practice. And surrogacy is a subject that has been getting more and more common these days. I think when I first started to practice, it was some 15 years ago. I think it was a kind of arrangement whereby the high net worth individuals would be able to afford to subscribe to such an arrangement. But now it's becoming more and more common. But anyway, enough about myself. Let me introduce my very esteemed panel. Further on the left, Dr. Laureen Hu. Laureen is a researcher at the Utrecht Center for European Research into Family Law. Her research focuses on rethinking parentage law from both a legal and moral point of view. Although adjustments have been made in parentage law in reaction to societal and technological changes, the ideal of a standard family, a married man and woman, and their biological children still lies at its basis. Laureen's research investigates the normative issues that arise in situations that deviate from this ideal, concerning, for example, unmarried fathers and surrogacy arrangement. As a legal expert, she works on a report for the Dutch Ministry of Justice and Security on multi-parent families. She also teaches several courses in family law and legal theory in Utrecht University. And the lady immediately on my left would be Dr. Nishat Hyder-Rahman. I have correctly identified you. Nishat is a postdoctoral researcher at, this one is difficult, Vrije University, Brussels? Yeah, no, it's VUB, right. As a postdoctoral impact fellow, Nisha is investigating the birth registration of children born via assisted reproductive technologies. Nisha's research interest lies at the intersection of law, ethics and technology in society. Nisha read law at the LSE and went on to complete her PhD in bioethics and medical jurisprudence at the University of Manchester, exploring the cross-border regulation of emerging biotechnologies. Her postdoctoral work has repositioned her within the field of family law, where her research has focused primarily on matters related to assisted reproduction, as well as the digitization of divorce law, particularly on algorithmic asset division. That is something new. It makes me feel like in Asia, we're actually quite backward. Okay, the lady on my right is Dr. Zaina Mahmoud. She's a lecturer with School of Law and Social Justice at the University of Liverpool in England. She is a lecturer in law at the School of Law and Social Justice in Liverpool University. Before joining Liverpool, she worked as a research associate at a fertility clinic on industry-based socio-legal research. And she held a socio-legal research fellowship at the University of Birmingham. She looks at the cultural environment promoting surrogates' autonomy, health, well-being by developing an alternative legal framework of surrogacy regulation informed by an examination of surrogates' life experience in Britain and California. She is also a co-investigator on children's voices in surrogacy law, a project that collects and analyzes children's view on surrogacy law reform. Her work may be found in a variety of academic journals and edited collection, and she is an editor of Future Directions in Surrogacy Law. Professor Nick Hopkins, further on my right, I think needs no introduction. He's a law commissioner for England and Wales for family law. He was appointed commissioner in October 2015 and reappointed in 2020. He led for England and Wales to join project for the England and Wales Scottish Law Commissions on building families through surrogacy. A new law, the final report and the draft bill for which was published in March 2023. As a commissioner, he also led other projects, family law projects, including enforcement of family financial orders. This is something that I need to know more. And weddings law. He's currently leading the commission's scoping project on financial remedies in divorce and dissolution. Prior to the appointment as commissioner, Nick was an academic for over 20 years, and he currently holds a chair in law at Reading University. He will take up a chair at UCL when his term of office as commissioner comes to an end in July 2025. Now, last but not least, Mr. Spencer Clarke on my far right. He is a lawyer, property, family and trust law team, Law Commission of England and Wales. Spencer is an interim joint head of property, family and trust law at the Law Commission. He began working as a lawyer at the Commission in 2013 and has focused on family law reform work. He was the lead lawyer for England and Wales on the joint project of the England and Wales and Scottish Law Commissions on building families through surrogacy, a new law. The final report and the draft bill for which was published also in March 2023. He has also worked on other family law projects, including matrimonial property needs and arrangement, enforcement of family financial orders, and weddings law. Before joining the Commission, Spencer was a solicitor in private practice, specializing in family law. So I will leave it to the capable hands of Laureen.
Thank you, Jonathan, for the introduction. And thank you to Jens and Jane and Daisy for organizing this wonderful event. I feel very grateful to be here. And just to clarify, I'm not a real doctor yet. I completed my PhD thesis, but I still need to defend it. But then, yes, I will continue working as assistant professor and lecturer in family law and legal theory. I'm writing the Dutch report together with Professor Wendy Schramme, who unfortunately can't be here today for health reasons. But the research that I'm presenting here is, of course, also based on her work. So yeah, I'd like to start off with explaining the current framework that we have on criminalization in the Netherlands and surrogacy. Yes, so in the Netherlands, there's no direct prohibition of surrogacy. Commercial surrogacy is counteracted with several provisions, and so it's meant to counteract certain actions that can happen during the course of the surrogacy arrangement. Then we're having more of a policy of tolerance towards altruistic surrogacy, so that is tolerated currently in the Netherlands, but it's also not encouraged. So the criminal sanctions do tend to discourage all types of surrogacy in the Netherlands. And we have three different types of preventative sanctions in the Netherlands. So, for example, the encouragement of surrogacy negotiations are prohibited. The promotion of intermediation services are also prohibited. And the public disclosure of one's wish to be or find a surrogate mother is also currently prohibited in the Netherlands. So when we look at the actions of the surrogate mother, as I just mentioned, it is prohibited to publicly disclose the desire to act as a surrogate mother. And yeah, and the image you see here, you can see this bow tie around her belly, and this is to symbolize that it's meant as an act of, for altruistic purposes, as an act of kindness for your friend, for example. And the idea of this prohibition is that you can, within your own social circle, offer your services to a friend. But if you go on the internet and leave an ad and say that you're willing to act as a surrogate, the idea is that then it is more likely that it's a case of commercial surrogacy. So that's why it's prohibited. But yeah, it applies to all types of surrogacy, but it is more likely that in practice it will deal with commercial surrogacy. Then when you look at the acts of the intended parents, you can see that it's, again, it's prohibited to disclose publicly your desire to find a surrogate mother. You can also, there are provisions on the unlawful placement of newborns in a foster family. So to place a newborn in a foster family, you would need a prior written consent by the Child Care and Protection Board. And a newborn is a baby under 6 months old. And you have a similar provision when it comes to the illegal admission of a foreign child for adoption. For such an admission, you first need permission by the state secretary. And then there are also provisions on forging information regarding the child's ancestry. So, for example, if you would hide the fact that the child has a different birth mother and perhaps even a partner who automatically becomes the child's legal parent at the moment of birth, then you can be held liable for forging information on the child's ancestry. And then there are other sanctions that could potentially apply in the course during an surrogacy arrangement, such as provisions on human trafficking, child abduction. So that we have provisions on that, but this is all theoretical. I'll come to that later because we don't have any prosecution cases yet. Then it is permitted to foster, to promote the fostering of a newborn child for pecuniary gain. This is considered a serious offense, so you're also not allowed to do this if there's no pecuniary gain, but then the maximum punishment would be less. It's also prohibited to encourage the surrogacy negotiations and arrangement professionally. So in the course of, in acting out your profession, I think there's in literature it's pointed out that if the stimulation of the negotiations were very structural and regular, then it can also fall underneath this provision. So even if you don't intend to make any money, but if you do this consistently help out couples in, for example, drafting a surrogacy arrangement, then in theory, I think you could be held liable on this provision. Then we have a prohibition to encourage a woman to leave the upbringing of the child to another person. The idea behind this is that it can be quite hard to prove that there was a situation of surrogacy, but because then you would need some preconception intent. And the idea is that even after the child is born, you would also need a provision if it's hard to prove that there was a case of surrogacy. So I think that was the reasoning behind this final provision. Then let me just go back to the previous slide. This would mean that, for example, legal agents drafting contracts could also be potentially held liable. But this does not really happen because there is a policy of tolerance towards surrogacy. So when you go on the internet, you can find some legal advisors helping couples out in drafting surrogacy arrangements. And this is the case for legal agents, but especially also for medical professionals. I think there seems to be focus in literature on high-tech technology surrogacy, wherein there's a policy of tolerance. But I think that in practice, I think also low-tech surrogacy is also not very strictly prosecuted, not for medical professionals, but also no legal agents. I think that there are guidelines of the Dutch Society for Obstetrics and Gynecology on dealing with high-tech surrogacy. And then there can also be disciplinary law sanctions within the medical profession. Then the main question is, how effective are these sanctions? At the moment, there are no relevant cases. I know that there are some cases wherein a Dutch couple was involved, but I believe Nishat perhaps will tell something about that, that in the end, Belgian law was applied, so no Dutch law. So we tried to look into this, and there does not seem to be any update on this. We don't have any relevant cases at the moment, and we also don't have any statistical empirical data on whether it does happen and to what extent, and we have so few prosecutions. Now I'd like to tell you something about the current regulation of legal parenthood in the Netherlands. In the Netherlands, we don't have a specific legal framework in family law dealing with legal parenthood. So the default rules for vesting parenthood ties and severing those ties apply. So that means that the child's birth mother automatically becomes the child's legal mother at the moment of birth, and that her partner also becomes the child's legal father at the moment of birth. It is possible to come up with a construction to eventually become the child's legal parents as the intended parents. So, for example, by means of adoption or the recognition of the child. But of course, this is a quite lengthy and complicated process, because then you would have to adhere to certain requirements. So, for example, there's a requirement of cohabitation and care for the intended parents to adopt a child. So this is also part of the reason why in the Netherlands a draft bill is pending to introduce legislation on surrogacy. I would provide some more further context first. So in the Netherlands, there is a discussion to accommodate modern families in family law. And this is also tied to the issue of the criminalization of surrogacy. In 2014, we had a new law that was introduced on lesbian parenthood. So then underneath this law, it was easier for the co-mother, so the female partner of the child's birth mother, to become a legal parent automatically at the moment of birth without going to a court. So she doesn't need to adopt the child. She automatically becomes the child's legal mother in addition to the child's birth mother because of this new law in 2014. But then it was argued that there are also other types of modern families that were not considered underneath this law. So, for example, two fathers, we need the help of a surrogate mother. They were not considered underneath this law. And it was seen as a kind of an example of an incremental approach in the Netherlands, wherein we want to move into a direction wherein we accommodate modern families, but at the same time, we lack a more coherent and fundamental rethinking of the system as a whole. So that's why we focused on lesbian mother families, and we didn't think about, for example, two fathers wanting to have a family by means of a surrogate. So in 2016, we had a very influential report by the State Committee on the Reassessment of Parenthood, and they looked at the whole legal system of parentage from the child's best interest point of view. And they thought about surrogacy, but also multi-parent families as well. And they suggested to introduce new legislation on surrogacy, but also on multi-parenthood. So that's why now currently a draft bill is pending on surrogacy. Underneath this draft bill, it would be possible for the intended parents and the surrogate mother to file for a joint request to grant legal parenthood before the conception of the child. So before the conception of the child, you can go to the court and you would need a signed surrogacy agreement as a requirement. The intended parents and the surrogate mother must also have engaged in a process of counseling. So they must be aware of the risks that might come up in a surrogacy trajectory. And you need a lot of extensive talks together. And at least one of the intended parents is also a genetic parent, and the identity of the donor must have been registered. So he can't be completely unknown, so that a child at a later point in his life can gather the information on his ancestry. And we have this, in the draft bill, the national track was considered, but also the international track. And for the international track, the requirements were very similar. So if similar requirements have been met and a responsible legal procedure has taken place, that means that a foreign court's decision can be recognized without a Dutch court procedure. And with this draft bill, a new sanction on commercial surrogacy is introduced. So the idea was to draw a clear distinction between altruistic and commercial surrogacy. So the idea with this draft bill is that it should become easier to follow the altruistic surrogacy route, but we still want to ban commercial surrogacy. So we would have an explicit prohibition that prohibits you from paying a surrogate mother. But it is allowed to reimburse her for the costs she made. So it is allowed to pay her, but not she can't have financial gain from it. And other sanctions will be loosened or lifted. So I think the ban on making your desire public, for example, will be lifted. And the prohibition to stimulate negotiations will be loosened. So this is, I think, will move the Dutch approach from a tolerant one to perhaps a more regulatory approach and a more facilitating approach. I think Wendy and I think that in general, the initiative to come up with regulation surrogacy is positive, But I do think there's still some downsides and aspects that we are quite critical of that need some further rethinking. But in general, I do think we're heading in the right direction, that at least we do want to regulate this situation, because we take a kind of a pragmatic approach that even if you have some ethical doubts, which are understandable, it might be better in best interest of the child to be pragmatic and come up with a regulation. But we do think it's kind of naive to maintain a sharp distinction between commercial surrogacy and altruistic surrogacy, especially when it comes to foreign surrogacy cases. Because, for example, the accompanying text of the draft bill refers to systems that they consider careful and responsible to procedures in the US, for example. But I think it's known that in the US, commercial surrogacy is very common. So this raises questions with us, like how does this align with the intent to maintain a strict boundary between altruistic and commercial surrogacy? We think that's not entirely doable. And I think a more comprehensive reconceptualization of parentage law is needed, because, for example, in this draft bill, we see that contracts will play a bigger role. They would have legal status and legal effect. But this issue is not only relevant to surrogacy, this is also very relevant for example, multi-parent families, who before the conception of the child would come to an agreement to create a child together that they both will raise together. And there's also a legislative plans on that to give legal effect to these types of preconception arrangements. And what I'm saying is that if we would allow for this draft bill to happen, then we would assign legal status to certain contracts. But it also raises the question then, what would happen to different types of preconception arrangements? Would we also give them a place in law, or would we still try to focus only on surrogacy and leave multi-parent families to different types of discussion? So I think this is also an example where we can treat this debate in a more fundamental manner and see like that it is not only about surrogacy in the moment, it's also about what is the role of contracts and agreements when it comes to vesting parenthood, what is the role of care, what is the role of pregnancy and the relevance of that, and how does that play a role in the system of parentage law as a whole. And I think that the current approach is a little bit too scattered, so to speak. But I do think in general it is an interesting direction we're heading towards. I'm not sure if the draft will get through, because the Dutch government has headed in a very different political direction than before. We are leaning towards a more right-wing and conservative political direction, and they don't seem to be very interested in surrogacy as a topic, or multi-parenthood for that matter as well. So I do think it's going to be very interesting to see if it will happen, and if so, when. But I do think it's more likely we'll have a regulation of surrogacy than multi-parent families. But it's still unclear when this is going to happen, and if at all. That's the Dutch perspective. Thank you for your attention.
And isn't it? So if that's the case, can I move over to Nisha to talk about the Belgian perspective then?
Hello. So first of all, thank you all so much for arranging this wonderful conference where we can share views from our respective countries, particularly to the organizers. You've done an absolutely fantastic job. So the criminal law, surrogacy, and Belgium. I'd like to start by giving you a general overview of the legal framework pertaining to surrogacy in Belgium before moving on to discuss the criminal law dimension in particular. So in Belgium, surrogacy is not expressly prohibited. It's also not expressly permitted. In fact, it's not directly regulated by any hard laws at all. And yet, surrogacy is openly practiced in Belgium. There are 5 fertility centres across the country that will offer their services in the context of a gestational or high-tech surrogacy. Despite the fact that there are no hard laws on surrogacy, it's not a total wild, wild west. And surrogacy is indirectly regulated via the law on contract law, parentage law, and also via the policies implemented by the fertility centres. And that's really more soft law. It can be classified as a tolerant jurisdiction. And as I hope will become clear throughout my presentation, some types of surrogacy arrangements are better tolerated than others. So altruistic surrogacy arrangements are better tolerated than commercial ones. Gestational or high-tech surrogacies are better tolerated than traditional or low-tech surrogacies. So in the absence of anything else, a surrogacy agreement will fall under the purview of the law of contract. Worry not, I'm not going to take you through Belgian principles of contract law. That's just there in case you're curious. But the classical view is that a surrogacy agreement will not be valid as a matter of Belgian contract law due to having an illicit object and cause. So in Belgian law, the law states that the human body is not available for disposition. And it's because of that, as well as the wide public policy clause, that the surrogacy agreement is seen to be having both an illicit cause and object. Now, the courts have not directly ruled on the enforceability of a surrogacy agreement. However, they've been confronted with the consequences of them via adoption requests, the recognition of birth certificates, and also the recognition of foreign judgments following a surrogacy. And it's in the context of dealing with those requests that some judges have commented on the surrogacy agreement itself. Within the jurisprudence, there is support for the classical view, and it's evident in the quote that I've got up on the PowerPoint. But it's widely held, both looking at the jurisprudence, but also within Belgian scholarship, that the surrogacy agreement is unlikely to be enforceable as a matter of contract law. Moving on then to the law on parentage, and in Belgium, the law allows for only 2 legal parents, and the rules on parentage are a matter of public order, so they fall within the rules on public order. When it comes to surrogacy, the surrogate will always be the legal mother, and that is because in Belgium, we also follow the rule that the woman who physically gives birth to the child is automatically going to be assigned the legal mother, and that occurs irrespective of genetic link. Now, this attribution cannot be contested very easily. There is a very, very small window through which it can be contested, and I'll come to that later on. But the attribution of legal motherhood to the person giving birth also cannot be relinquished or transferred prior to birth, or even immediately upon birth. So the person who's given birth can only consent to the adoption of that child 2 months after birth. Unlike in neighbouring France, there is no option for anonymous birth in Belgium, and there is also no legal mechanism to establish legal motherhood on the basis of a genetic link between parent and child. And this is in contrast to legal fatherhood, though indeed the sperm wins. Concerning legal fatherhood, if the surrogate is married, her married partner is automatically attributed legal parenthood. If the intended father in a surrogacy arrangement is genetically related to the child, he can contest that presumption, so the presumption of legal fatherhood by a marriage, by proving paternity and recognizing the child under Article 318 of the Civil Code. And this can only happen under certain conditions. So the surrogate must consent to this happening, and the surrogate's husband must also not be in what translates as possession of state. So it means that he cannot be acting as the parent or seen socially to be acting as the parent. If the surrogate is unmarried, on the other hand, the intended father can recognize the child prior to birth, and he would be the legal parent from birth under Article 319 of the Civil Code. So when it comes to surrogacy, the surrogate will always be the legal mother upon birth. One intended parent, mainly the intended father, can usually demonstrate a genetic link and therefore establish legal parenthood that way. The other parent, so the intended mother or the other intended father, can then adopt the child to establish parenthood. And this is the pattern that occurs more often than not in Belgian surrogacy cases. It's also the fact pattern that Belgian fertility lawyers will advise their clients to expect. So this is very sort of standard practice. I mentioned that the intended mother or the other intended father must adopt. And in Belgium, adoption must be based on lawful grounds. When it comes to surrogacy, there is some controversy over whether or not a surrogacy arrangement can be seen as lawful. Now, there are three different approaches that have been taken, both in the scholarship and via the courts. The first is that all surrogacy arrangements are contrary to public policy, and therefore adoptions are always going to be impermissible following a surrogacy arrangement. The second is that some surrogacy arrangements are contrary to public policy, and therefore some adoptions are possible. And in the jurisprudence here, you see that the courts are far more likely to agree to an adoption request following an altruistic surrogacy than a commercial one. The third view is that adoption must be assessed on its own terms entirely and completely independent of the surrogacy arrangement that preceded it. Now, the case law tends towards the latter two options, and that is what is more prevalent these days. But there is also no consistency across case law either. So the courts, certainly the Ghent Court of Appeal in 2012 refused an adoption request by an intended mother following a domestic commercial surrogacy arrangement. But other courts have agreed to the adoption request, even when it is known that there has been a commercial surrogacy arrangement. So there is not consistency, but the more dominant view in recent jurisprudence is that the law and the judges must prioritize the best interests of the child. So it's moving in that direction. Okay, I mentioned that the fertility centers are involved in the regulation of surrogacy, and in the absence of any specific regulations, the centers themselves are gatekeepers of formal surrogacy in Belgium. So each center has its own very detailed set of protocols on the criteria that they will follow in order to pursue a surrogacy arrangement. And there is some variation across the fertility centers, but they are all clear that their services are only available for altruistic, gestational, or high-tech surrogacy arrangements. And finally, the last little bit on the civil law framework, the treatment of foreign surrogacies. So it's no surprise that there are no specific rules for foreign surrogacies, and in the absence of that, the general principles of Belgian private international law will apply. Now, when it comes to foreign surrogacies, there's no concrete policy from the Belgian Parliament or legislature on surrogacy and how it should be approached. And in the absence of that, the Belgian authorities, both in the embassies, but also within the local authorities in Belgium, have quite a bit of discretionary power in whether or not they will recognize foreign birth certificates. So they can refuse the recognition of a birth certificate on the grounds of evasion of law or public policy. And in fact, they very often do. This is not necessarily because they have taken a policy line that they're not going to recognize these, but it's rather because there is no clarity on how they should act. They choose to refuse the recognition and then throw the question to the courts to see how the courts will deal with it. So how have the courts dealt with it? Well, again, the case law is not wholly consistent, but the courts have been quite creative, and they will often partially recognize a foreign birth certificate. So they will recognize the genetically linked intentional father, and then the other parent, so the intended mother or the other intended father, will have to go via the adoption route. So it really mirrors the domestic situation. That said, recently there have been several cases where both intentional parents have been recognized, genetic and non-genetic, intentional mothers as well as intentional fathers directly. And in those cases, it's been clearly stated that what must be taken into account foremost is the best interests of the child. Okay, so the criminal dimension of surrogacy in Belgium. Surrogacy is not a criminal offence in Belgium, and parties to a surrogacy arrangement are not committing a criminal offence by partaking in a surrogacy arrangement or even contemplating it, regardless of the characteristics that it takes on. They might, however, commit an existing crime in pursuit of the surrogacy project. Now, I should say that the criminal has very rarely been used to regulate or police surrogacy in Belgium, and so there's really limited jurisprudence on this. There are 3 reported cases that have involved criminal sanctions, and I'd like to tell you about them in just a moment. Before I get into those cases, I'd like to point out that the use of intermediaries or agents is not common in Belgium. There is some anecdotal evidence that there are intermediaries, but nothing formal. And I think the reason for this is that commercial surrogacies are not tolerated, so the fertility centres simply won't deal with them. And also the structure of the healthcare system in Belgium really encourages direct contact by the intended parents and their surrogate and the clinic. There are no reported cases of criminal liability against a professional agent, intermediary, legal advisor, healthcare professional, or a fertility clinic to date. Advertising actually is allowed, and this is because it's not around. So every year in Brussels, there is an annual conference or fair called Men Having Babies. And it's essentially where private fertility clinics from the USA and Canada come and they show the services that they have to offer. It's held in Brussels every year. The next one's in November. And every year, this conference is very heavily picketed and protested. And it has in the past triggered a bill to ban the advertising of surrogacy services. That bill was unsuccessful. But no doubt the protesters will be there in November again. Okay, moving on to the cases. The first one I'd like to talk to you about is the case of baby Donna. Now, this case involved a Belgian surrogate and Belgian intended parents, and they met via a website and entered into a surrogacy arrangement for the sum of €8,000. Now, this was a traditional surrogacy arrangement. It was a DIY procedure at home using the intended father's sperm. The surrogate, after the pregnancy had been established, told the Belgian intended parents that she miscarried. In fact, she went on to make a new arrangement with Dutch intended parents for the sum of €12,000 plus expenses. Now, this became public, and all the parties involved were convicted of subjecting the child to degrading treatment under Article 417 of the Belgian Criminal Code. The surrogate and her husband were given a 1-year sentence and a fine. It was a suspended sentence, and they were also forced to forfeit the payment that they'd received. The Dutch intended parents were fined, and the Belgian intended parents were initially convicted, but they were later acquitted upon appeal. And that's really interesting and important. So the judge made it clear in his judgment that it was the fact that the surrogate had resold to the highest bidder, to use his words, that triggered the application of Article 417 So it wasn't the commercial surrogacy arrangement in itself, it was really the element of trade. If anyone's curious, and I always am, baby Donna remained in the care of the Dutch intended parents. The next case I want to talk to you about briefly is the case of baby J. Now, this isn't actually a surrogacy case, although in Belgian scholarship, it's often discussed in the context of surrogacy because the facts are somewhat analogous. And it's interesting to see how it might have played out if it was a surrogacy case, but it's not a real one. So following an unwanted pregnancy, a Belgian couple arranged to transfer the child after birth to a Dutch couple for payment. So you see, it's not a real surrogacy because the pregnancy was already in place. I'm going to refer to the pregnant woman as the surrogate just for ease of reference. So she agreed to use the Dutch intended mother's personal identity details at the hospital, and she and her husband also agreed to use the intended parents' details for birth registration. That didn't go so well. She actually gave her own details and later had to tell the nurse that she'd given the wrong name and address. And how this didn't trigger the hospital's suspicions, I don't know, but it didn't. The intended mother actually later shared her story quite publicly, and that's what triggered an investigation. So the pregnant woman, the surrogate, for want of a better word, and her husband, and surrogate's mother, who was involved in the arrangement, were prosecuted for subordination of the child. And this is where a child was attributed to a woman other than the birth mother. So there is that very small scope for for challenging the attribution of legal motherhood, and this is it. They were also prosecuted for forgery of documents, as well as the use of false deeds, abandonment of the child in a destitute state, and degrading treatment of the child. Now, the surrogate and her husband were given a 1-year suspended sentence, a fine, and they were also forced to forfeit the payments that they'd received. The mother received a 3-month suspended sentence, and the Dutch intended parents were criminally investigated and dealt with by the Dutch authorities. But they wouldn't have come up under the surrogacy provisions that you referred to, because it's not a surrogacy. The last case I want to tell you about is the case of M&M. And in this case, a Belgian surrogate used donor sperm in a DIY at-home procedure to conceive and carry a child for a Belgian single intended mother for €13,000. It was later discovered that the resulting twins were actually genetically related to the surrogate's husband and not the donor. And that's interesting for the parentage case that later came up. So after the birth, the intended mother applied for an adoption, and it was during that procedure that she was prosecuted for seeking to obtain an adoption in bad faith, namely following a commercial surrogacy arrangement. And she and the surrogate's husband were both prosecuted for degrading treatment under Article 417 bis. The surrogate in the intervening period had died, not because of the pregnancy, but for other health reasons. But the intended mother and the surrogate's husband were convicted and given suspended sentences. The twins actually remained in the intended mother's care, but in her capacity as a foster parent. So the adoption request for a full adoption was not granted, and she remained a foster parent. The surrogate's husband could then, as a genetic parent, he could then claim paternity. I'm not going to discuss this one. Perhaps it will come up in the questions, but not for now. So looking at these 3 cases, and it's all we have to really build any kind of narrative on Belgian criminal law in the context of surrogacy, we can take away that criminal law is really used to target domestic commercial surrogacy arrangements. It's interesting to note that all of the procedures that were targeted by criminal law are all DIY at-home procedures. So surrogacy arrangements that go via the fertility clinics are actually relatively unproblematic. And it's because the clinics are really quite rigorous in their screening procedures. So arrangements that go via the clinics will firstly, very few of them actually make it through screening, but then once they do, they flow quite well. There are no Belgian criminal cases targeting foreign commercial surrogacy arrangements. The Baby Samuel case that I was going to talk to you about, but I don't think I have time, was a foreign commercial surrogacy arrangement, but the criminal sanctions were not imposed by the Belgian authorities, but Ukrainian ones. The other thing to take away is that sentencing is quite light. The sentences are all suspended sentences, the fines are quite low in comparison to what they could be, and usually the payments are deferred in any event. So why hasn't the full extent of the criminal sanctions been used? Well, there are a number of reasons. Certainly in the Baby D case and in the M&M case, the children ultimately remained with the intended parents. And it was seen that it was in their best interest to remain with the intended parents because those were the only parents that they'd ever known and the only people who'd ever cared for them. It's also seen as not in the best interests of the children or child to have their parents put into prison or financially depleted once the decision has been made to let them stay with them. So there is that. Also, I think that because surrogacy occupies a grey area in terms of its legality in Belgium, the courts are really quite reluctant to step in and carve out a hardline policy and use the criminal law in that manner, particularly when it's an area that really does just demand legislative attention. So how efficacious is the criminal law? Well, it's hard to say. It's not used to its fullest extent, and that's perhaps on purpose. These high-profile cases, and they were quite high-profile, they were splashed all over the newspapers. Well, they occurred sort of unfolded during the early to mid-2000s, and it's possible that they had some deterrent effect on domestic commercial surrogacy. Sorry, it's a typo. It shouldn't say gestational, it should say commercial. But there have been very few cases. Certainly no new prosecutions have been reported, so perhaps the deterrent effect worked. But really the policing of surrogacy is done via the civil law, particularly the law on parentage. So the Belgian authorities just make it very difficult for parents to actually, or intended parents to become legal parents in certain circumstances. But there seems to be no real appetite for the use of criminal law to regulate surrogacy. And that can be seen even in the most recent developments. So last year, the Belgian National Advisory Committee on Bioethics issued their opinion on the ethical principles that they think ought to underlie surrogacy. 2 weeks ago, they also issued their opinion on the impact of those ethical principles on law. And nowhere in those opinions do they refer to the use of criminal law or criminal sanctions. The Liberal Party in Belgium have also got a bill on the table to regulate surrogacy. And that bill too does not make any mention of the use of criminal sanctions or nor any amendments to the criminal code proposed there. So really there seems to be no appetite for the use of criminal law in this area. And I will stop there. Thank you.
Thank you, Nisha. We now go over to United Kingdom. I see there are 3 speakers here, and they're all going to talk about law reform in the United Kingdom.
Thank you so much to the organizers of this fantastic conference for a great excuse to make it to Hong Kong, which has been on my bucket list for ages, and for the amazing opportunity to talk about surrogacy in England and Wales. So I'll provide a general or an outline of the legal framework. I will give a spoiler now. Traditional and gestational arrangements are treated similarly under UK law as are domestic and transnational arrangements. From there, I'll talk about the criminalizing surrogacy and how that works in the UK, the consequences on parenthood, whether criminalization thus far has been effective, and I will not talk about future directions. I will leave it to the law commissioners to do that. So, in the UK, surrogacy is regulated by the Surrogacy Arrangements Act 1985, the Human Fertilization and Embryology Acts 1990, 2008, and a large body of case law. What we can see is a legally tolerant approach, so there is some level of disapproval, or at least historically there has been, and we can trace that to the early development of the framework. The Warnock Report in 1984 outlined recommendations for assisted reproduction. Surrogacy was dealt with, albeit briefly, in one chapter, and the recommendations contained within the Warnock Report aimed to thwart the growth of surrogacy as a practice, but there was a recognition that completely prohibiting it was going to be impossible. Criminalization was undesirable, and in particular, the phrase that we see in the Warnock Report is a desire to ensure that children are not born under the taint of criminality. And as I'll go on to say, that's why surrogates and intended parents are not criminalized for their behavior with regards to surrogacy arrangements. As the Warnock Committee was finalizing their report, the British tabloids and the British media were hit by the baby cotton case, Vrije. And in this case, which was the first commercial and compensated traditional surrogacy case in the UK, Kim Cotton, the surrogate, gave birth to a baby girl who was left in the care of the hospital in the London Borough of Barnet until her parenthood could be decided. And the judge in this case allowed for the intended parents to be recognized as the parents, as this was in the best interest of the child. What's interesting is how the media representation of this case influenced, to a certain extent, the legal regulation of surrogacy. So in this case, the Commercial Surrogacy Agency, which was an American surrogacy agency that had a London offshoot, was blamed for what had happened. They were described as greedy and profit-oriented and responsible for baby selling. And we see a lot of that terminology around the baby cotton case. So commercialization was seen as the time bomb that was primed to explode. Looking through contemporary parliamentary debates and Hansard reports demonstrates the level of disapproval with commercialization. In response to the baby cotton case and the media coverage of it and the moral panic surrounding it, what we see is the Surrogacy Arrangements Act 1985. It was a very rushed approach or a very rushed endeavor to incorporate what the Warnock report had outlined. It was only ever supposed to be a time-limited measure. It was never supposed to be the legal framework or the basis of a legal framework for surrogacy in the UK. It had a very specific focus on prohibiting commercial surrogacy. And I think it's quite important to outline what commercial means within this context. It is not whether the surrogate is compensated or whether she or whether they are receiving any payment, but instead it's the third parties involved in the negotiating, making, or facilitating of a surrogacy arrangement. So when speaking about commercial surrogacy, it's whether that third party is being paid. For commercial, what the SAA says is that they will receive a fine not exceeding £5,000 or imprisonment, but it requires the non-personal consent of the Director of Public Prosecutions. Since the Surrogacy Arrangements Act 1985 was such a rushed and time-limited response to baby cotton, a lot of it, or since it was so rushed, there were many issues that were left outstanding that the HFEA Act had to remedy. So importantly, the fact that it was unclear whether surrogacy contracts were enforceable. The HFEA Act outlined that no, in fact, they would not be enforceable contracts, and inserted Section 1A into the Surrogacy Arrangements Act 1985. There was some uncertainty about the parenthood of the child, and we see the codification of the mother being the person who gives birth as the legal mother. And at this point, we see that there's no distinction drawn between traditional or gestational arrangements. Genetics plays no role in whether the surrogate would have been considered the mother or not, which is why at the start I said there is no distinction drawn between the two. We also see the introduction of the parental order. And what's interesting when looking at the historical development of surrogacy regulation in the UK is that the parental order was actually quite rushed. It was a last minute change to the bill because one of the MPs, his constituents, had gone through a gestational arrangement and were unsatisfied, unsurprisingly, by the fact that they had to adopt their own child. So we see the introduction of a parental order, which is a bespoke legal mechanism allowing for the transfer of parenthood from the surrogate and their partner to the intended parents. This in itself signals the more tolerant approach towards surrogacy. In 2008, we see an update to the HFEA Act, and additionally to the parental order requirements, we see it all shifting to reflect the changes that we see in society. So Section 54, and then later on 54A, for single intended parents, updates the requirements for a parental order, allowing same-sex couples within the eligibility of parental orders, and then later on single applicants are also allowed. However, there are still requirements such as domicile, genetic link. At least one intended parent has to be genetically related to the putative child, and other things, which I will get to. The issue is that courts are presented with a fait accompli when looking at both domestic and transnational arrangements, and it is very unlikely, in fact, it has never been seen, where it would be in the best interest of the child to remain with the intended parents. Obviously, this is something that we've seen throughout the various jurisdictions discussed today. What's interesting about the HFEA Act is the allowance of non-profit organizations. So they are now allowed to receive some payment for limited services related to surrogacy, and they're able to do so without breaching that prohibition against commercialization. So I'll now move on to the different sanctions, and as we'll see, there aren't very many for those involved in surrogacy arrangements. So if we start with surrogates, we see that they face very little working by way of criminal liability. So they're excluded from the scope of all the prohibited commercial activities under Section 2. Again, this whole idea of not wanting the child to be born under the taint of criminality. Advertisements are technically illegal, but there hasn't actually ever been a criminal conviction. So you can't advertise that you want to be a surrogate or that you're offering your services. But again, there hasn't been any criminal conviction. Similarly, with intended parents, they're also this whole desire to not have the child be born under the taint of criminality means that they also face very little by way of criminal liability. There is also no extraterritorial jurisdiction for the Surrogacy Arrangements Act or the HFEA Act. meaning that if intended parents go abroad for surrogacy, there's no criminal liability there. So there's a tacit acceptance of transnational commercial surrogacy arrangements. What we see in Re X and Y is a reconciling of the domestic prohibition for commercialization with the recognition that people will go abroad to pursue surrogacy arrangements, and here to designate whether this amount that has been paid to the surrogate is acceptable. The courts will ask 3 questions as to whether the sum was disproportionate to reasonable expenses, were they acting in good faith, or were they attempting to defraud the authorities. Again, there hasn't been a case of a refuse parental order on the basis of how much the surrogate or the agency has been paid in a different jurisdiction. Going back to the fact that the Surrogacy Arrangements Act had that very myopic focus on prohibiting commercialization, we see that agents and or intermediaries are the ones who kind of receive the brunt of any criminal liability if there were to be prosecutions. So in Re G, we see the fact that there haven't been anything in place to regulate surrogacy organizations. So unlike fertility clinics and other assisted reproductive technology, surrogacy organizations had no code of practice, had nothing really there. And there was quite a few surrogacy organizations that began to emerge from the 1980s onwards. So Kim Cotton founded COTS, Childlessness Overcome Through Surrogacy. We then see Surrogacy UK popping up in 2002. In 2013, Brilliant Beginnings, and then in 2019, My Surrogacy Journey. So in 2007, we see that as a result of this lack of standards, as a result of this lack of regulation about what they can do, that there is no recognized standard of competence, that issues do emerge when we have these third parties involved in surrogacy arrangements. And that's what gave rise to Section 59 in the HFEA Act, which allowed for-profit organizations to receive some form of payment. That in itself is another hint as to this increased tolerance of surrogacy. So the parental order being the first step towards increased tolerance, and now the second one being the nonprofit organizations being allowed to receive some limited payment. The other step towards this increased tolerance can be seen in 2019 with the Department of Health and Social Care releasing guidance for the first time, endorsing surrogacy as a valid way to form a family. This in itself was quite big because it demonstrated quite a significant shift from the 1984 Warnock Report position, from disapproval or reluctant tolerance to now acceptance of surrogacy as a valid form of creating a family. The guidance has since been updated a few times, with the latest update in April 2024. In that guidance, we also see the recognition of 4 nonprofit surrogacy organizations. So they're the ones that I just discussed: COTS, SUK, Brilliant Beginnings, and My Surrogacy Journey. They play quite an important role in the social organization and understanding of surrogacy as well. In terms of lawyers and legal advisors, again, it's important to recognize the fact that the legal framework was very much devised to prohibit or to thwart the growth of commercial surrogacy, and lawyers are not allowed to provide paid legal advice to help in the negotiating, facilitating, and making of a surrogacy arrangement. And it's the scope of Section 2, that's the prohibition against commercialization, has been understood by lawyers as precluding them from being able to provide advice. And there's been one case where there has been a surrogacy agreement that was drawn up by solicitors who were paid, but there was nothing in that case related to whether they were not sanctioned in any way. They had no prosecutions, nothing was there. And since then, a lot of lawyers will write, or will try not to write them, because the organizations do take on that role, and they are allowed to do so if necessary, but only on a pro bono basis. For healthcare professionals, the broad scope of Section 2 does include healthcare professionals. Now, importantly, that does not mean that it means that they can't be paid to negotiate, facilitate, or make the surrogacy arrangement, but they are perfectly capable and within the law, going through IVF, doing all of the things associated with surrogacy. So they're allowed to practice, and in fact, there is a thriving private IVF. IVF is privately provided for the most part in the UK, and that is perfectly permissible. Surrogacy is perfectly permissible to be undertaken in these clinics. The healthcare professionals are bound by the HFEA Code of Practice, and what we see with the Code of Practice and how these clinics interpreted the regulations surrounding surrogacy is that they see it as a difficult thing. There's quite a bit of research about how clinics and healthcare professionals view surrogacy as difficult, taking up a lot of time, and with difficult parties as well. Part of it is the fact that the Code of Practice itself and the different consent forms and everything aren't actually fit for purpose for surrogacy. There are cases that demonstrate that. So the one case in particular, the Jennings case last year, dealt with a widower who wanted to use the last remaining embryo he had created with his wife that was in storage. She had passed away. He wanted to use it in a surrogacy arrangement, but the consent forms hadn't actually allowed or ever considered that would be a possibility and had to then be updated following this case. So the Code of Practice is evolving. Everything is evolving to recognize that surrogacy is being practiced and should be regulated. And there should be some kind of guidance provided, but within the confines of the fact that the law had always been devised to thwart commercial surrogacy. So with parenthood, which is kind of the biggest thing with surrogacy, the HFEA 2008 Act was accompanied by the 2010 regulations, and they cemented the fact that the court has to consider the child's welfare as its paramount consideration. So with that, the final straw is set here, because we see that there's nothing that's going to, or very little will mean that a parental order won't be granted. So it is basically guaranteed. And that makes it quite difficult for any commercial sanctions to actually be applied. Once again, going back to this idea of having children not be born under the taint of criminality. So even where we see instances of surrogacy where there might be something that isn't allowed for the parental order, so like I said, the requirement for a genetic link, if there is double donation, so neither intended parent is genetically related to that child, what will happen instead is that the courts will allow for alternative approaches or alternative orders to secure their legal parenthood. So we see a reluctant use of adoption orders in various cases, reflecting the fact that it wouldn't be in the child's best interest to not have people raising that child as legally recognized as their parents. A child arrangements order is an alternative to the adoption order. This one confers parental responsibility without transferring legal parenthood. And we've seen a few cases, and there have been cases since, where a child arrangements order has been granted if the surrogate does not provide consent, because this is one of the cornerstones with fertilization, or the HFEA has consent as a cornerstone, and so does the surrogacy, and so does its applicability with surrogacy arrangements. Then we can look at advertising. Like I said earlier, surrogates and intended parents are not caught by that restriction against commercialization. With Section 3 of the Surrogacy Arrangements Act, advertising isn't permitted, and it is quite far-reaching. So all forms of communication and publication are caught within that. However, the ban on advertisements is routinely breached. When I was doing, even before I actually started doing empirical research on it, I would see tons of ads on Facebook, even on Twitter. You would see people advertising that they were willing to be a surrogate or that they were looking for a surrogate. There are tons of groups online as well for that purpose. However, there's never been a prosecution in related to advertising, so we can see that this prohibition isn't actually enforced. I will leave it then to the law commissioners to take over and look at the future directions in surrogacy law in the UK.
Thank you, and thank you very much, Zaina, who has provided a really comprehensive picture of the position in the UK at the moment, which makes it much easier for us to explain what we have recommended in order to sort of update the laws. I want to begin by thanking Jens and his colleagues, not only for this conference, but for the numerous conferences on surrogacy that he has organised during the course of our work, and for the really sort of constructive support that's provided throughout the consideration we've made of surrogacy. I think most of you are aware of who we are and what we do, but if if we're new to you, then in essence, the Law Commission of England and Wales is an independent body. We were established by Parliament back in 1965 by an act that places us under a statutory duty to keep the law of England and Wales under review and make recommendations for reform to government. We are funded solely by central government, but work independently from them. The same act that set us up also set up the Scottish Law Commission, and whereas in relation to surrogacy, we're looking at a law that applies across England and Wales and Scotland, we work jointly with the Scottish Law Commission. And so our project on surrogacy was a joint project conducted by the two law commissions, led by me for England and Wales, and by Professor Gillian Black at the Scottish Law Commission. And there's a project that began in 2018. We published a consultation paper, which, as with all of our projects, included a number of questions and provisional proposals. We received over 600 responses to that consultation paper, which we used to put together our final report back in March 2023, which we published along with a draft bill and with a core report that sort of summarizes how we anticipate our recommendations would operate in the majority of surrogacy cases under them, which would run, we hope, to course. So I'm going to talk primarily about the recommendations we have in our report that relate to criminal offences and relate to issues of enforcement that sort of raise a question of where do you use a criminal offence and where do you rely on some other means of enforcement. But to do so, just provide a very brief overview of the main recommendations that we made. We provided recommendations for a new surrogacy law that would respect the intentions of the parties by having the protections that currently take place when, as Zaina said, the court is presented with that fait accompli. We would move those protections up front to before the surrogacy agreement is entered into and before the child is conceived. They would protect the autonomy of the surrogate and provide safeguards against exploitation. They provide clarity on payments while retaining the altruistic non-commercial basis on which surrogacy operates in the UK. And vitally, they would put the best interests of the child at the heart of surrogacy law. They would move the UK from the tolerant approach that's classified as in the book that Jens referred to this morning to a regulatory approach to surrogacy. And so key to our recommendations is what we describe as a new pathway to legal parental status for domestic surrogacy agreements. So onto this new pathway, for the first time, checks and safeguards take place before the agreement is entered into and before the child is conceived. And being on the new pathway enables the intended parents to be the child's legal parents from the time of birth, as long as that remains the shared intention of the surrogate. If the surrogate withdraws her consent to the agreement, then the decision as to who the child's legal parents are will be taken by the court, and the primary interest for the court will be the best interest of the welfare of the child. On the new pathway, the intended parents and surrogate will work with a new type of organisation that we call a regulated surrogacy organisation, or RSO. These organisations act as the gatekeepers of access to the new pathway and would be regulated by the Human Fertilisation and Embryology Authority, so the UK's existing regulator of fertility treatment. They would also be non-profit making bodies. The parental order process would continue to exist so that courts could continue to make decisions on legal parental status for children born through surrogacy outside of the new pathway, and that would include all international agreements. Now, in the UK, there are many individuals and organisations who support and endorse the use of surrogacy and there are many who oppose surrogacy as a matter of principle, some of whom wish to see surrogacy criminalised. And we heard from and engaged with the broad spectrum of views across the course of the project. While we work independently from government, the starting point for our work is government's view on surrogacy. And as Zaina has explained, that view has moved from one of sort of tolerance to one of supporting surrogacy as part of a range of assisted conception options. So our project was never designed to consider whether surrogacy should be prohibited, let alone criminalised. It was undertaken to review the problems with the current law in the context in which Parliament permits surrogacy and the UK government supports its use. Now, within that framework, we took into account previous reviews of surrogacy, including the 1984 Warnock report, which, as Zaina has explained, was careful to ensure that the birth of a child was not tainted through criminality, a view also expressed in the later Brazier report of 1998. We agreed with that point, and throughout the project, we're keen to ensure that however the criminal law was used, it was not done in a way that would taint the birth of the child with criminality. In our view, doing so would be contrary to the paramount focus on ensuring that the law of surrogacy operates in the best interests of the child. But there are criminal offences contained in the draft surrogacy bill that accompanies the publication of our report. These criminal offences relate to activities connected to surrogacy rather than to the practice of surrogacy itself. And they also relate to the making of false statements by intended parents in relation to the surrogacy process. We also made recommendations in relation to imposing civil penalties, which are not part of the criminal law, but again relate to enforcement. And I want to talk about those criminal offences that we recommend. But I'll begin with looking at what we say about payments that are made to a surrogate through surrogacy, as it was this issue that I think raised particular difficulties for us in respect of enforcement and caused us to think in particular about the role of criminal law and the role of sort of civil penalties in enforcing the law and how those two sort of related to the welfare of the child. Our recommendations on payments are informed by two key objectives, and these are to protect against the risk of exploitation of women who become surrogates, while also ensuring that those women are not left financially worse off as a result of being a surrogate. And so the approach we took was to identify certain categories of payment that we recommend should be permitted payments that the intended parents can make to the woman who becomes their surrogate, with all other payments being prohibited. So the permitted payments include, for example, the sort of costs the surrogate would incur in relating to the surrogacy and in relation to the surrogate pregnancy, and costs in maintaining contact with the intended parents and the child following the birth of the child. Prohibited payments are any others, and they include all of those payments that are compensatory in nature, or payment for the service of being a surrogate, the service of gestating the child and giving birth to the child. So we have a scheme in which some payments are permitted and others are prohibited. And that gave rise to the question, how do we ensure that this distinction is enforced? How do we ensure that the intended parents are only making permitted payments at the surrogate, and what should happen if prohibited payments are made. One of the key criticisms of the current law is the absence of any effective means of enforcing the existing limitations on payments. The only sort of form of enforcement available in theory at the moment is that if a court finds that the surrogate has received more than her expenses reasonably incurred and does not retrospectively authorize those payments, then it would have to refuse to grant the parental order. Zaina has explained, granting parental order, the paramount consideration is the welfare of the child, and unsurprisingly, a court has never held that the making of overpayments means that it would be in the best interest of the child not to grant the parental order when presented with that fait accompli. In our consultation paper, we suggested that removing surrogacy agreements from the new pathway where prohibited payment had been made, along with regulatory action against the regulator surrogacy organisations, would be an effective means of enforcement. We relied on the fact that the surrogate and intended parents had a shared intention to ensure that the intended parents would be the parents at birth, so they wouldn't want to act in a way that jeopardised that. And the regulator surrogacy organisations had an interest in ensuring that limitations on payments were complied with, so that they were acting in accordance with the licence that they operated under. Consultees weren't convinced by this analysis and were concerned at the idea of overpayments removing the surrogacy from the new pathway. But there was support amongst consultees for the view that enforcement should not take the form of a criminal offence, because that would be contrary to the welfare of the child and would taint the birth of the child with criminality. And so in light of the consultation responses, and after a number of discussions we had, including at one of the conferences in Cambridge organised by Jens, we took a different approach in our final report. So the RSOs, the regulator surrogacy organisations, may still be subject to sanction by their regulator if overpayments have been made, because that might indicate that they're not sort of properly doing their job of ensuring that intended parents and surrogates understand what payments are permitted. But the surrogacy agreement would remain on the new pathway, so that the making of an overpayment did not impact on the legal parentage of the child. Instead, we recommended that following the birth of the child, intended parents using the new pathway would have to make a statutory declaration as to the payments that they had made. Under the existing law, knowingly and willfully making a false statement on the declaration would be a criminal offence. And we also recommend introducing a new criminal offence of the intended parents unreasonably failing to make that statutory declaration within 12 weeks of the child's birth. So they can't simply avoid criminality by not making the statutory declaration. We considered that in these circumstances, it's not the birth of the child that has been tainted with criminality. The criminal offence relates to something sufficiently removed from the birth. It's the dishonesty of the intended parents in making the statutory declaration, so as not sort of to taint the birth of that criminality. In the parental order process, if the intended parents made a false statement about the payments made, then that would be a contempt of court. So there's parity between the new pathway and the parental order process in terms of criminality. Importantly, in both cases, it's the intended parents alone who are making the declaration, and they alone who are at risk of criminality if they make a false declaration. So the surrogate is supported or is protected in that way. She does not commit any offence by receiving an overpayment, and nor does she have to sort of declare or sign a declaration that overpayment has not been received. We also explored the possibility of introducing civil penalties when overpayments are made. So not a criminal sanction, but a financial penalty on the intended parents in order to deter prohibited payments being made to the surrogate. This led to the question of who would enforce those civil penalties. The options open to us seem to be either the HFEA or the regulator surrogacy organisations. The HFEA told us the surrogacy organisations should impose them. The surrogacy organisations told us the HFEA should impose them. So there you are. Ultimately, we decided that government should consider whether to introduce a scheme of civil penalties. And we took the view that if it did, the enforcing body should be a state body. So we set out some of the features that a scheme could take, that it would apply to the new pathway into parental order cases alike, but not to international arrangements. And the penalty should be linked to the amount of the prohibited payment. So it could be some multiplier of that payment. We recognise that there could be sort of some disadvantages of a scheme. It could discourage domestic surrogacy, or for wealthier intended parents, the payment, the penalty might just be seen as an additional cost to factor in to the surrogacy. But we think it could strike a balance between ensuring effective enforcement of the payment scheme on the one hand, while still avoiding the taint of criminality on the other. So I'll turn very briefly to the criminal offences that are included in our draft bill. These relate to activities related to surrogacy, so in particular, what we describe as matching services, so services provided that essentially enable intended parents and surrogates to match and to form a surrogacy team, and the provision of legal advice for negotiating and drafting surrogacy agreements, and also to advertising services that you provide that are relevant to surrogacy, whether that's the services of a regulated surrogacy organisation or legal advisors or sort of medical healthcare professions who provide services relating to surrogacy. In essence, what we have recommended is that there are the particular organisations, particular individuals who should be able to provide these services and advertise that they provide these services, and for others to provide those services would be an offence. In relation to advertising, we loosen the current prohibition on advertising, but we don't go as far as we had provisionally proposed in the consultation paper. In our consultation paper, we took the general view that if an activity is lawful, then it should also be lawful to advertise it. So we recommended removing the prohibitions in the 1985 Act that Zaina has outlined. That approach was not supported by consultees. And so we recommended keeping some of those limitations, including on intended parents and surrogates advertising their own intention to enter into a surrogacy agreement. We acknowledge that the existing prohibitions have not been enforced, and yet we recommend that they are retained, which is quite an interesting position in itself, and one that has resonance with what we heard about some other jurisdictions this morning. But we felt that there was still some importance in the messaging that prohibition gives. We're also concerned about how about where the line could be drawn between a lawful and an unlawful advert. So the example, or one of the examples we give in our report, is that given that commercial surrogacy remains prohibited, if intended parents advertise that they were looking for a surrogate and the surrogate would be well looked after, was that an implied advert for commercial surrogacy, or was that simply stating an intent to enter into a good surrogacy relationship with the surrogate? So in the end, we decided that there were still advantages in keeping the prohibition, even though it's one that has not so far been enforced. So I think I will leave it there. Our report, we said, was published last year. We await government's response. We, of course, have a new government in the UK. And so we continue to engage and see if the government decides to take our recommendations forward. Thank you. Okay, hello again, everybody. You thought you had heard quite enough of me for a little while, and I've come back. But welcome to the continent of Africa. So a slight switch in the programme. You'll see we spent a lot of time in Europe, so we have just popped over to Africa for this session, and then we'll go back to Europe for the final session of today. And we have 3 jurisdictions to go to. First of all, Professor Julia Sloth-Nielsen, Professor at the University of Western Cape, South Africa, is going to take us to South Africa. Julia, I think, needs no introduction to anyone here. She has all of our respect for the fantastic work that she has done and continues to do. I'm told she's about to publish a 750-page commentary on the African Charter on the rights and welfare of the child, undoubtedly destined to be the foremost legal commentary on the Charter. And speaking as a law commissioner, all I can say is, 750 pages, that's a bit short, Julia. Secondly, Gladys Murugai-Makundai is going to take us to Kenya. Gladys is a researcher at the University of Western Cape, South Africa, and at the Dullah Omar Institute, a leading think tank based at the university. Her research focuses on the intersection of poverty and human rights in Africa, gender perspectives and housing laws and policies, and the impact of organised crime on the rule of law and anti-corruption efforts. And then Professor Maria Usang Asim is going to take us to Kenya. Maria is an associate professor of international human rights law at the University of Western Cape, South Africa, and she undertakes research, teaching and learning responsibilities also at the Dullah Omar Institute. She's an expert in children's rights law and works in close collaboration with the African Committee of Experts on the Rights and Welfare of the Child, the committee's partners and civil society organisations involved in realising children's rights in Africa and globally, contributing towards the fulfilment of the committee's mandate. So 3 sort of fantastic speakers for us, and I'm going to hand over first of all to Julia.
Thank you very much, Nick, if I may. And thank you also to the organisers. And I'm the guilty party who allowed these forms to be handed out this morning. So I do hope to see some of you at least at the Family Law Conference in Cape Town following the Surrogacy Conference. I'm doing double act here. And you could get my email address from Candy if you don't find it some other way. In case you want to give me a topic or a paper, then we can group you into sessions. We usually have about 150, 200 presenters over the course of 3 days. And we've been dealing with surrogacy at that conference since 2006. And I remember it so vividly because I had just invited a very well-known figure in international family law, Professor Katerina Bulavorki. For the first time, I picked up her details, also from a pamphlet. I had invited her to come to Cape Town to the conference, which she did. And when she saw the program, she said, "You can't have a session on surrogacy. It's illegal." That was almost 20 years ago. And it's just instructive how the world has changed in 20 years. That takes me to my presentation today, because by that time, 2006, the Children's Act 27 of 2005, I brought a copy with me in case you've got nothing to do tonight for some bedtime reading. It had been finalized, but for various reasons related to provincial and national competencies, the entire act only came into force from 2010. But it was very clear that surrogacy was on the cards. And to be frank, there's a history. Surrogacy was tacked on as a chapter to the Children's Act by the researcher at the South African Law Reform Commission, because there had been already in 1994 a Law Commission inquiry into surrogacy following on a very high-profile case where a grandmother gave birth to her grandchildren, but she was the surrogate for her daughter, triplets, which of course hit the Sunday Times, and there was no regulation. So there was therefore a Law Commission investigation, which had been completed but had gone nowhere because there was no political clout or demand in Parliament, particularly at that time. So it was simply tacked onto the Children's Act to get us somewhere through the process. So the main characteristics of surrogacy, and I'm repeating things we've heard all day today, altruistic surrogacy only is permitted. And the Act expressly says surrogates may not use surrogacy as a source of income. It's only available to persons domiciled in South Africa. Pre-fertilization approval of a high court is required. And the child becomes the child of the intended parents immediately upon birth. There's no parental order or adoption required. And another interesting point is that due to the constitutional prohibition on discrimination, both hetero and same-sex surrogacy are permitted. There's a very strong reproductive rights clause in the Constitution, which allows a surrogate to opt for a termination, whether she is genetically related to the child she's carrying or not. At any time, she must simply give notice to the intended parents. And the third thing is the paramountcy of the best interest of the child, which is a constitutional right. And you will see how that develops just now. Now, there are no express provisions governing international surrogacy, should South Africans travel abroad. But in the view of one leading academic, and I agree, there's very little likelihood of that ever happening because cost-wise, surrogacy in South Africa is on a par with surrogacy in other parts of Africa and much cheaper than California. There might be other reasons occasionally, for instance, the need for a genetic link requirement may not be able to be fulfilled. And the genetic link requirement was constitutionally challenged in 2016 in a highly contested case, the details of which are given to you there, and it was upheld. Would a foreign birth certificate be recognized? It's unclear, but in my view, it's very likely that it would, even in the face of commercial surrogacy. And I base my argument on the case of ex parte MS 2014, which I will tell you about just now. The other piece of legislation which governs aspects of the medical aspects of ART are the regulations to the National Health Act of 2012. These were revised in 2016, but never finalized. I have a copy that was re-revised in 2022 and still not finalized. And the revisions were relied upon, strangely enough, unadopted though they were, to try and resist declaration of some of the regulations as being unconstitutional. And the court just struck this out and said, well, that's a hope. We don't know if they'll ever be finalized. You, the Department of Health, can't rely on provisions that haven't actually been formally adopted to say that this cures the defect. So that process may still unfold. As mentioned, they deal with the clinical aspects of ART, who can perform it, where it can be done. Regulation 21, which is the last regulation, provides for criminal sanctions for anyone contravening any provision of the regulations, which I will mention shortly just now. And the fine or imprisonment seems a bit heftier than some of those that have been mentioned earlier, namely fine or imprisonment not exceeding 10 years imprisonment, should they be contravened. Can IVF be performed prior to confirmation of a surrogacy agreement in anticipation? Now, this was put to the test in a very recent case, MCM. An infertile couple who wanted to use surrogacy but had not yet found a surrogate mother. So they asked for a declaratory order that they could proceed with having embryos created in anticipation. The court acknowledged there were good reasons for them to act proactively, as it were, but said the regulations clearly did not permit this. The National Health Act and regulations make no provision for so-called home insemination, or what somebody else has called today DIY insemination. So there's no prohibition on this. So going back to the Children's Act, Section 305 of the Children's Act is an omnibus provision which covers the entire Act and all of the criminal sanctions pertaining to everything in it, from foster care to children's homes, and so forth. And amongst the omnibus provision are the sanctions for surrogacy. So what are they? Firstly, promising or giving a reward or compensation in connection with an SMA, except only if you provide legal or medical services. And I think I will refer to Nick Hopkins' previous slide. I think the South African legislation is more or less on par with that. Courts will accept costs of maternity clothes, loss of earnings, medical expenses, counseling, but not payments for gestation. And in this second case, it was HPP and others, 2017. This was during the confirmation proceedings, which is always held in Canada, in chambers. The court discovered that the attorney had disclosed a separate contract with payments to an intermediary. She called herself she wasn't a clinic, she was a surrogacy consultant. She had in the past acted 6 times, the past 11 years, as a surrogate herself, and regarded herself as uniquely qualified to assist people with psychological support. She wasn't a psychologist, managing any dispute resolution, and in general overseeing the surrogacy journey. Court said no, this would allow commercial surrogacy to sneak in through the back door, and the court cannot condone commercial surrogacy directly or indirectly. But the contract with the facilitator was simply excised from the overall surrogate motherhood agreement and declared unlawful, meaning it couldn't be enforced. A further agreement with the fertility clinic between the intended parents and the surrogate was nevertheless confirmed and approved. No criminal proceedings, therefore. Ex parte WH was one of the very first reported cases on surrogacy after the Children's Act came into operation. And the courts laid down a whole raft of rules about what needs to be included in the papers of the lawyers. The affidavit must specify that no facilitation fee for introducing the surrogate and intended parents has been paid. In contract law, such agreements will be unenforceable anyway. Expenses directly related to the act must be declared. This is in advance. And lump sum payments have been discouraged, 3,000 Rand or whatever, how many that is in Hong Kong dollars. Lump sum payments per month can just conceal a commercial endeavor. Second, contravention of Section 302 is a criminal offence. The section deals with protection of the identity of parties to court proceedings, without the written consent of the parties concerned. And further to this, no person may publish facts which reveal the identity of a person born as a result of the SMA. This too is a criminal offence. The usefulness of this provision is very questionable. I had a student write a master's thesis last year, very good one, and she documented numerous instances of surrogates and intended parents posting their personal experiences on social media. And this was just the experiences. Additionally, as was mentioned a short while ago, it doesn't take rocket science to realize that there are numerous websites where women advertise themselves as surrogates, obviously quite clearly with a commercial motive. Whether they ever had any takers, I don't know. Third, Section 303 criminalizes certain acts. No fertilization before the surrogate mother agreement is confirmed, and not after 18 months either. No person may, with a view to compensation, make it known that a person might be willing to enter into an SMA. But again, I come back to the case I thought I would just refer to of ex parte MS in 2014. Here, the Johannesburg High Court was confronted with an application for confirmation at a stage where the surrogate was already 33 weeks pregnant. In fact, by the time the case judgment was handed down, she was 37 weeks pregnant, which is obviously a contravention of Section 296 and Section 303 of the Children's Act. Yet, court granted the confirmation order. Court was satisfied that the intended parents had good reasons, not necessarily good ones, for failing to get pre-fertilization authorization due to 2 failed previous attempts at surrogate-born baby. So they then entered a verbal agreement and waited until the pregnancy had stabilized, and then went to see a lawyer and found out that they had contravened the act. The court held that the best interests of the child are of paramount importance, not as in the CRC, primary importance, but paramount importance. And the surrogacy arrangements are all about the child to be born. And to be adequately protected, the law requires scrutiny before there's even any prospect of a child coming into being. That's a quote. Can the court confirm the surrogacy agreement notwithstanding the breach? And a very tortuous explanation, which is clearly legally very suspect, the court ultimately decided that the provision made in the agreement was for the upbringing, welfare, and interests of the child that is to be born. So that would include children that are conceived and not yet born. So the court could confirm the surrogacy agreement, a clear contravention in the view of most commentators of the actual wording of the law. But it also means that if the child has already been born, then the court cannot confirm a surrogacy agreement. The next issue is what the purposes of these provisions might be, which is also one of the questions in the questionnaire. The first one, the court said, is legal certainty, because the intended parents become parents immediately upon the birth of the child, with one exception, which I will refer to in a minute. And the second one is the best interests of the prospective child. And then the court also said the legislature did not expressly say post-conception confirmation is unlawful, provided other requirements are met. The court continued to say clearly, obiter, that IVF, in other words, practiced by the fertility clinics in the absence of a court order, is unlawful. Now, going back to the National Health Act regulations, they define who's a competent person to perform IVF. They require counseling. In a recent case of QG versus CS in 2021, C and A were a lesbian couple wanting to start a family. They found a sperm donor, they saw a lawyer, they concluded a known donor agreement. He donated, they went off to the fertility clinic. She fell pregnant, baby was born, and he'd agreed no contact. But at some point, the respondents moved into a rental house on his small holding, and he got to know the child. And then when he discovered that they were planning to immigrate to Australia, he went to seek an order for parental responsibility as the genetic father of the child. The courts did not accede to this request, allowing the new family to have the space that requires protection and insulation from outside interference. But the fertility clinic did not adhere to the counselling requirement, and it's argued quite strongly that if there had been counselling, the known gamete donor would have realized what the implications were before entering into this agreement. The aims and purposes of criminalisation, I think, have already been highlighted in MNS. Deterring commercial surrogacy, legal certainty, ensuring the best interests of the child, and ensuring no exploitation of poor and vulnerable women. In my experience, most of the women who have acted as surrogates, and some of them have been to our conference from time to time, brought by lawyers, have been very poor women. And there's a deep suspicion that there is an element of commercial benefit that is at stake. There's certainly many, many rumors about contraventions of the commercialization ban. So what are the consequences? A surrogate mother agreement that does not comply with the Act is invalid, but I speculate in the paper that legal parentage, so lack of pre-fertilization sanction endorsement is an obvious example, as I just mentioned, in relation to ex parte M&S. So adoption might secure legal parentage if this was not valid. Just to mention something I said I'd come back to, where the surrogate mother is genetically related to the child, i.e. her own gametes were used, she may, according to the Act, terminate the surrogate mother agreement within 60 days after birth. I think it's very rare that fertility clinics use the gametes of the surrogate mother for fear of the agreement not holding after the birth of the child. Efficacy of criminalization. There have been no prosecutions despite rumors of contraventions. There was a Children's Act Amendment Bill. I drafted the surrogacy parts of it, which for reasons totally unrelated to surrogacy, didn't make it through the parliamentary process, and I've heard of no rumors to resuscitate it. It was an omnibus amendment to the Children's Act. So therefore, the real remedy is the court sanctioning process, which can be quite rigorous, and the possibility of the Health Professions Council getting involved with medical practitioners or clinics who flout the law. Thank you.
Good afternoon, everyone. My name is Gladys. I must apologize. My voice is a bit hoarse. I'll try my best to be as clear as possible. Thank you. So I'm presenting on criminalizing surrogacy in Kenya. And listening to Prof, I must admit Kenya is very far from having regulations. As it is, we do not have regulations, although surrogacy does continue as it is. So surrogacy motherhood has been continuing in Kenya with the first incidents in August of 2007. But since then, in terms of legal developments, there's been no framework to regulate the arrangements. exposing the practice to corruption and other exploitative activities. Being a new technology, the practice is still stifled with uncertainty in terms of ethical issues and the persons involved in the process. With no dedicated law governing surrogacy, therefore, the parties involved, and where there's contestation, the Kenyan courts have had to address the issues with the existing laws, primarily with the Children's Act and the Birth and Registration Act. The Birth and Registration Act, in particular, defines birth of a child from its mother after 28 weeks, which presumes that the legal mother of the child is the woman who carries and gives birth to the child, and therefore excludes surrogacy arrangements. With the Children's Act, it provides parental responsibility, child adoption, child custody, and child maintenance. It does not provide for specific protection of children born out of those surrogacy arrangements. At the moment, there's a parliamentary bill still pending, and this is a journey towards a legal framework emanating mainly from two legal matters. So the proposed bills is the Assisted Reproductive Technology Bill of 2016, and the bill introduces, tries to clarify legal parentage on surrogacy arrangements. It also allowing for altruistic and non-commercial surrogacy, and establishes the Assisted Reproductive Health Authority to oversee the industry and ensure privacy and human dignity. The bill was followed by another bill, Reproductive Health Care Bill, which tried to expand some of those definitions. And most recently, the Assisted Reproductive Technology Bill, which was pushed by the Medical Council in Kenya. All of these bills are still pending, but there's been major opposition from some conservative policymakers, as well as particular religious groups. And there's been a lobby, an online lobby, mostly advocacy. And the critics argue that the creation and potential disposal of surplus embryos during IVF, they view it from a morally unacceptable due to the disregard of the embryo's inherent value. There's also the issue of genetic material as a commodity in surrogacy, which they equate to human trafficking. Is open to debate, as well as dehumanizing both the embryo and the children born out of surrogacy arrangements. And thirdly, there's an argument that surrogacy disrupts the traditional view of procreation as a natural and divine process within marriage. And I mean, these are just a few that have been dominant, but there's continuing conversation on this from various religious groups, as well as non-government organizations that do not support the bills in parliament. The key, so there's been key rulings on surrogacy, and we hope that those, so far there's only been 3 cases in court, and 2 already have a decision. We're hoping that with those, although it was in 2014 and 2015, that there's going to be a momentum towards having these bills considered by Parliament, that they come into law. So the contested rights in these 2 major cases was primarily on identity, rather around, I mean, in the surrogacy arrangement, the issue was who was to be registered as the parent in the birth certificate. And the court allowed this petition partly sympathetically, acknowledging that the Kenyan legal system was ill-prepared to handle cross-border surrogacy arrangements. What happened in this particular case is that WKN and CWW, who are the commissioning parents, when they went to collect the children, they were twins from the hospital. Unfortunately, the director of child services had taken them to a children's home pending the decision of who should be registered as the as a parent in the birth certificate. And the issue, therefore, was whether the director violated the petitioner's right to privacy. And the High Court found that the hospital did not breach the petitioner's right to privacy, revealing the existence of a surrogacy arrangement, although they had wanted that to be concealed. As to whether the children born through surrogacy arrangements would automatically be deemed children in need of care and protection, the court was clear that the director of child services did not act in the best interest of the children, particularly since there was no dispute between the surrogate and the genetic mother. As to whether the recognition as a birth mother and a parent under the law of registration of births in Kenya, it is common ground that will be a dispute, and High Court decided on this particular matter that the birth certificates should be issued in the name of the commissioning parents and not the birth mother. And so the courts haven't had a common view on this particular one in terms of registration of birth mother. So it's still contested, but in this particular case, the Judge Majanja allowed it. So there isn't, what I'm trying to say, there isn't a common practice. It is case by case decision. So what is the efficacy of criminalization of surrogacy in Kenya? And here I want to highlight the social cultural considerations, in that some communities in Kenya have traditionally adopted unconventional approaches to surrogacy under certain conditions, especially when a woman is unable to conceive or bear a child. Here, the wife herself might arrange for another woman to bear the children for her husband. A practice would say traditional surrogacy, for lack of a better term, where the children are considered to belong to the wife who sought the surrogate. And here, the surrogate is integrated into the household, a setup influenced by community cultural norms, and the surrogate and the intended father maintain a platonic relationship and are not legally married. So this particular practice is common among the Kamba, Kalenjin, and Abagusi tribes in Kenya. So trying to put that together with trying to consider the social cultural considerations as well as the absence of a legal and ethical guideline. There's been loopholes and there's been incidences of fraud and illegal practice. And one of the practices, and I'd say this is where criminality comes in, there's been identity forgery, where the surrogate uses the commissioning mother's identity throughout the pregnancy and birth, allowing the commissioning mother's name to appear in the birth certificate. Another illegal method involves obtaining a forged birth notification from a medical facility, avoiding the lengthy adoption process. So that's a loophole that definitely needs to be viewed, and hopefully with the regulations, and if the bills are passed into law, that loophole will be covered. There's also some legal tensions in surrogacy arrangements at the moment. There's reproductive rights, focusing on the individuals involved in the surrogacy arrangement. There's a lot of discussion on whether surrogacy is a human rights issue and a reproductive right issue shouldn't at the moment be pushed by civil society organizations dealing with human rights. Policymakers at the moment, there's an open door to civil society approaching Parliament, but there's also tension of who proposes these amendments in the bill. So I suppose that's also, civil society has to be very strategic on how they present the matter. There's also the children's rights, addressing concerns of the child and the children born from such arrangements. There's also the issue of parental rights. It adds another layer to the discussion, and the rights of the women who bears the pregnancy, often on primary childbearing duties. So, and this is a form significant to the debate. We need to also consider them. So what's at stake here? Definitely, there's a rise on surrogacy in Kenya at the moment, and it happens in private. And not all matters have been able to reach court, so there is no data based on these arrangements. We do not know what are the standard templates for this arrangement. For instance, when there's an agreement, there's been incidences where surrogate mothers have come forward, and it's mostly in the media to say they were not paid after their services. So despite this significant development, presenting new legal challenges for family law, there's concerns, and the judicial cases addressing surrogacy have reflected on this. So there's lack of clarity and consistency on the surrogacy as a sexual reproductive health right. There's lack of specific regulations, creating uncertainty for individuals involved in the whole arrangement. And then criminalization of surrogacy would require a prior political discussion on what is the new legal asset to be criminally protected. Is it distinct from that which is already protected in existing law? So that's a big debate to see how we can fit in. Do we really need a new procedure in criminal law, or can we work with what we have? Thank you.
Thank you very much, Gladys. So, Lilia, take us to Nigeria.
Right. I would also like to begin by thanking you for this conference. And the reason is because this particular topic is a very fast-moving issue in Nigeria at the moment, like it's at the center of everything. And you would find information, material here or there, but it's hidden. You wouldn't really find any comprehensive thing. So this actually gave me an opportunity to begin to try to gather the information in a very coherent manner. For example, one of the latest developments we had is as a result of a lot of advocacy and pushing, there is still a bill that I'm going to make reference to on this subject. And in February of this year, it had been at the National Assembly. And in fact, I've been pushing. That's why it took me a while before Jens could get my paper, because I kept on struggling. I've been trying to get the current bill, the bill in its current form. And that had been a struggle. Also because it's just a few days ago in this month that it passed second reading. So we wanted to kind of get a sense of what is it saying? Does it take into account all the issues we've been raising over the years and what have you? But it's been silent, zero silent. In fact, that's why I was here on my phone, because I was with a colleague of mine who's at the National Assembly. Can I see what that bill looks like at the moment? And I just received it. So, so that's what I'm saying. It's for us, it's very relevant because it's ongoing right now. And typically, obviously, when it has gone through second reading, you can almost be sure that it's going to be passed, right? And what was interesting to note is the words in the media report, the words of the particular senator or member of House who was pushing, who kind of sponsored the bill. It makes sense when you understand the Nigerian context, because it said, first, the bill seeks to eliminate all forms of discrimination, exploitation, and will support and encourage struggling couples to have children. So when it speaks to discrimination, the reason why surrogacy is kind of hidden, it's very widely practiced, called by different names, traditionally and culturally. It's very widely practiced, but under the radar. And just similar to what Gladys was saying, subject to a lot of abuse, exploitation, and what have you. But culturally, I think one of the reasons why it has stayed hidden for so long is because of the stigma attached to the woman's role. If she doesn't have a baby, it's like, you're not complete. So people do it in secret, in hiding. We've also had cases of mothers who serve as surrogates for their daughters. And that's one of the most common ones that happens, because there you're almost certain that the news is not going to be publicized to the whole world to hear. And then it becomes a stigma that, oh, you couldn't have your own child and this happens. So it's kept a lot under the radar, even though it happens. Now, part of what has made it come out more in the limelight or into the limelight in recent years is, first, you have big stars or celebrities, a couple who have had children as a result of surrogacy, who are now willing to come out and say, these were my struggles, and eventually I went for surrogacy and I'm happy that I now have this child, I have 2 children. So the more they come out to talk about it, the more it's like, okay, they're removing the stigma, and people are like, oh, if this big star went through this and is willing to speak about it, then we should listen and not feel, so ashamed. So in that context, that's the one. So you have people like stars in the Nollywood movie industry, like Iniedo and co. And then you have a former beauty pageant, Miss Nigeria or whatever, Nikki Oshino, who got married to a medical doctor, also welcomed her baby as a result of surrogacy. So all coming out to say it. Now, that has one impact on one hand. And then you have when you think about the religious, how the stronghold that religion has on the country, because that's another area where resistance has come from, the religious sector, whether Islam or Muslim, which are the two major religions in the country. Then when you have, there are some big churches or pastors or imams or what have you, you don't have one or two wives who have come forward to say they also welcome their children as a result of surrogacy. So it's like, okay. So more and more, it's making the issue out there. And a lot of movement has been, there's been a lot of concerted effort with it. It's been like more multi-sectoral, because you've had lawyers working with doctors and journalists and all coming together to say we need to push the agenda to get something done about this. Also because we have a proliferation of what they call baby factories. I'll talk more about it in a second. Baby factories are all over the place in Nigeria, so where terrible conditions, women, especially even girls, young girls actually, in most cases, are put there against their will just for this express purpose of having babies who are then given to others, sold to other people. So because of the lack of regulation of laws on surrogacy and the stigma attached to it, it has given rise to that kind of thing happening under the radar, and people know even when they don't talk about it. So now more and more, with all those stakeholders coming forward. In fact, there is in April of this year, there was a major kind of conference at the national level. So you had lawyers, medical doctors, and others who are involved in anything to do with law and ethics, including surrogacy. They organized it and came together to shed more light on it and heard testimonies from other people who are taking part in surrogacy. So that concerted effort has been pushing the agenda. In fact, you had some journalists, female journalists, who went undercover as potential commissioning parents just to investigate and find out what is happening behind the scenes. So all of the revelations that they brought to the fore were some of the things that were being combined to say we need to make a case for regulating this subject matter in the country. There's no other way to go, about it. So that has made a lot of difference in, I hope I'm getting this right. Oh, thank you. Yeah. So it has made a lot of difference in where things are at the moment. So things are moving, like I said. And I'll make reference to one or two things in the current bill that I just got. But basically, similar to some of the presentations we've had today, it's in a legal gray area, so it's neither explicitly permitted or prohibited. We just know, okay, it happens with all the legal challenges associated with it. What has been most common is to use Rule 23, and that happens more for those in the medical profession, because their own ethics provides for assisted conception and rules about it, including acknowledgement of gestational surrogacy, permitting donation of gametes, and the rest. But generally, there has been no legal framework guiding the issue. The first bill was in 2016 that was introduced in the National Assembly to amend specifically the National Health Act in relation to assisted reproductive technology. However, it had a lot of shortcomings, and this led to a subsequent bill being introduced. Now, this one clearly more defines the rights and duties of all the parties involved and what have you, and allows for compensation and all. But again, like I said, things have moved from here because the bill that currently is so short, it's really maybe 6 or 7 pages long. And the first part of it is telling you about the regulatory bodies or the commission set up to do it and those who are the members of the commission. So there are ongoing developments at the moment and trying to deal with it. Now, the last point I put there was just because to say, again, because of the stigma and how quiet things have been around surrogacy, advertising, you would ordinarily think it would be very unpopular in the context. But we're actually discovering the contrary, because now with media, social media and all of those things, you have people who are actually getting information about surrogacy organizations online, they're finding online advertisements and the rest. And that's how some parents are contacting these people. Again, spotlighting why regulation is necessary, because there are lots of unscrupulous people who put up such adverts and all, but they may just be a front for a baby factory I was talking about. Now, in the absence of such any particular law criminalizing surrogacy, there are other laws in existence that have been used, continue to be used, depending on aspects that can be defined as exploitation or human trafficking. And I mentioned the key one there, it's the Trafficking in Persons Act of 2015. And those who are most at risk under that law are those who fall into the category of agents or intermediaries, right? Because they are the ones who operate for profit and most times don't adhere to any ethical standards. And that's where, again, the baby factories comes into play. Similarly, intermediaries can also be prosecuted under broader criminal laws, such as child trafficking laws, fraud, or other exploitative practices. Another very important set of people who are at risk are the medical professionals, and that's why they were so much at the forefront of regulation, because you actually have some medical practitioners who are involved in the baby factory, whatever you want to call it, business. So you actually have qualified doctors, nurses, and what have you also involved as something they do on the side as a way to make money because of the absence of regulation and laws. So a lot of those in the medical profession have been at the forefront because they want to preserve and protect the integrity of their own profession and their own personal reputation. They've been at the forefront of pushing for regulation in the country. Again, point 2 there is where I want to focus on here. Another reason why surrogacy has been a major topic in the country. Everyone knows Nigeria is a populous country. However, the infertility rates are high compared to the majority of the other African countries. So it has one of the highest rates. So like a third of couples struggle to conceive after 12 months of trying. And that has been proven. So it's been another reason why they're like, we cannot not talk about this and make a plan for it. So it pushes us to keep talking about it. So at the moment, given the way the laws are, even the few cases where surrogates have commissioned or have been relied upon to help couples to conceive, whether at home or abroad, because in some cases, because of the absence of regulation, you have those who go outside of the country to countries, for example, in South Africa, where they know that there is regulation to try to get services there before they come home, even though then there are other hurdles that they have to go through, establishing parental responsibilities and rights over those children. So you keep finding lawyers being creative. For instance, in one of the laws, they are required to adopt those children formally, again, after having conceived them through surrogates in order to safeguard themselves and to avoid potential conflicts. But it's not clear in cases where there is a contestation, even by the surrogates, what happens? How do we resolve, the issues and the conflicts that come up? So that has never been clear. The bill I referenced is what I note in the second point there. And to date, of the 36 states, because Nigeria operates a federal system of government, so there are 36 states, as well as a federal capital territory. And Lagos State is the only one which in 2009 came up with some kind of legal framework to guide on assisted reproductive technology, including surrogacy, which is not a surprise because it's commercial center of the nation, it's the hub, that's where most of these things happen. In fact, the baby factories, the majority of them are not in Lagos, they are in some rural areas because they're hidden, they have to be hidden. So people take a lot of risks just to access them. So in some cases, you would find somebody has disappeared and she's back and there's a baby and you're not supposed to ask her. She went, that time she was not around for all those months. She was actually pregnant. She didn't want, she struggled for many years. She didn't want attention. And if there are evil forces, they know and see that she's pregnant, so she didn't want to take any chances. That's why she disappeared for some time. Now she's back with her baby. Whether it's true or not, you have no idea. In many cases, they are just clients of some baby factory somewhere. So they've gone to get a child, buy a child from somewhere and just return back into their communities and societies. So even though these new guidelines for Lagos State were established in 2019, we've still been trying to kind of assess how effective it's been. Because if you remember, just after 2019, we had COVID hitting us in 2020. Nobody was paying attention to anything. But even in that same 2019, there was already this case that came up that I highlighted in red, because I think, if I remember correctly, these guidelines came in around May of that year. And this was a continuing case from either November of the previous year or flowing into 2019 and beyond. So it was the case of this lady called Gift Danjuma. She was a surrogate mother who had a baby, and she ended up having triplets actually via cesarean section. Then she developed severe pains and complications, leaving her unable to conceive again. And the doctor said the only way is if she undergoes some complex surgery. Medical reports could not be found. And what was interesting and made it quite scandalous is the fact that St. Nicholas Hospital is supposed to be one of the affluent hospitals, where the rich go to for such services. She couldn't find the reports, and all parties involved were denying responsibility for her current condition, who's going to pay for this surgery, she has to have it, and all what have you. So those were some of the controversies that again brought to the fore the need for action to be taken, and we're spotlighting it, and I'm still trying to follow up on where this has landed. So since we don't have a lot of things are limited, you cannot necessarily assess the effect of criminalizing surrogacy itself, because like I said, we are still in the process of getting an actual law to regulate it. But I wanted to focus a bit more on the baby factories that I've been mentioning, just so that you get a sense of it, because it's a particularly problematic thing. And in the context of the African Committee of Experts on the Rights and Welfare of the Child, where Prof. Nielsen used to also sit, it's one of the things that has come up before the committee as to what is the government doing about it, because lots of children. So it's not just about getting children for those who want children, it is children being used to have children in a lot of cases. So many of the mothers are under 18 in those factories, to have children for people undercover. So they are usually hidden, but they're converted spaces in the various hidden parts of different cities or towns across the nation, with involvement of many medical personnel. Between just 2008 and 14 alone, 20 baby factories were discovered. And over 290 women, many of them girls, were discovered, right? So a lot of the focus has been on curbing and destroying these factories. That is what the government has been facing. And part of the challenges we had was trying to present a clear case to the government to say we understand that the baby factories operate and it's a crime and these are the problems with it, but you cannot on the basis of that not look into surrogacy, that they're not one and the same thing, because the way the media kept on reporting about the baby factories, the moment it's like surrogacy and the baby factories are the same thing. So that was a major hurdle to try to overcome and say, no, it's not the same thing. Yes, this is one thing. It's a problem. We must tackle it and deal with it. But it's not, it doesn't mean that it's the same as surrogacy. And just even trying to get people educated on what surrogacy means and how it operates and all of those things, because a lot of the news, a lot of the law enforcement efforts have been on the baby factories. So we've been trying to make that delineation so that we can achieve what we want to do. Now here, I won't go into all of them, but what we did was to present some of the narratives of some key people, like the celebrities I talked about, the journalists who went undercover, and those who are speaking, giving us positive reports about surrogacy. So either those who were surrogates or those who were commissioning parents at different points in time. So we have the narratives of their experiences and why they went into it and what the outcome has been for them. Some of them are very encouraging. So generally, this is where things are. But I want to end, if you don't mind, just giving you a quick highlight of the main things that I'm seeing in the bill. So basically, it eliminates or prohibits commercial surrogacy. That is clear. It says surrogacy arrangements for commercial purposes are prohibited. No person shall be paid or receive any consideration or benefit. And there'll be penalties. Now, Section 10 here says only married couples who have been medically certified as unable to carry or conceive a child to term are eligible to enter into a surrogacy arrangement. And then in the case of a single person, they may be eligible if they have a medically certified as unable to conceive or carry a child to term. Now, the reason why I wanted to highlight this is that's why we've been having a challenge and struggling to get a copy of the bill, because we know that some of the things will not necessarily align with what we've been pushing for. Because already you could see, so you have to be married, you have to be medically certified as unable to conceive or carry a child to term. And then if you're single, you have another set of hurdles to go to. And so those are some of the things we've been saying, trying to address in advancing sexual and reproductive health and rights within the general framework of human rights. That's why we've been like on the sidelines trying to push, can we see what it looks like so we know how to say, no, this is not what we were aiming for. And that's why it's been shrouded in a lot of secrecy. But as a like, in the media reports now, of course, it's to take a lot of credit for it. And I want to give you a few keywords from one of the sponsors. According to him, the first thing I said, it seeks to eliminate all forms of discrimination, exploitation, and to support and encourage struggling couples to have children. This kind of law is not a law of force. It is a law of choice. Because this is about you wanting to have children and choosing to say, would I go this route to have my children or not? It's not a law that says everybody must have children through surrogacy. It is not a binding law. I know it is not going to be accepted fully everywhere at once because of culture and religion. So again, like I said, it is not a forceful law, but a law put in place so that when anyone wants to get involved in it, there are laws guiding it. So this is already preparing them for potential backlash, but still without taking into account all of the elements that those at the forefront of this subject have been pushing for. So that's why I said it's a moving target. It's ongoing at the moment, and we continue to wait and see where it will take us. I'll leave it there for now. Thank you.
Thank you. Thank you. We have very interesting contributions coming up in relation to both Ireland and Italy. Our two speakers for this panel, first, Dr. Claire O'Connell, who's a board member of LGBT Ireland and a member of the steering group of the Parenting Alliance. She holds a PhD on the topic of how Irish law can recognise intending parentage while vindicating children's right to identity in assisted HRT. And that's from the University of Cork. And she's very widely published on the subject that we're here today to discuss. And the other speaker for this panel is Dr. Marco Poli, who's a postdoctoral researcher at the University of Turin. Marco has a joint PhD from Turin and from Antwerp, and has a wide range of interests, research interests in family law, children's rights, socio-legal and gender perspective, etc. And he's widely published both in English and in Italian in the subject. So without further ado, turn over to Claire for the first of our contributions.
No, I might go standing up. That's okay with everybody, just for the late hour that's in it. So hello, thank you so much. I am so grateful to be here and for the invitation in such lovely surroundings and with such solid air conditioning. So I'm just going to take you through the efficacy of criminalising surrogacy in Ireland. So to start off, just to explain, so the surrogacy legal framework in Ireland is the Health Assisted Human Reproduction Act 2024. So we only just got it. But basically it's split up into 4 quadrants. So you have past and future, international and domestic, and wherever you fall depends on what the standard is applied to whenever you go for your parental order. So you might kind of ask yourself, okay, well, what separates the two? So here, I don't know if this phrase translates very well, but the fire is supposed to show a dumpster fire of a situation, so just a terrible mess, which is that at the moment, this legislation has not commenced. So we have it, it took about 10 years, and now that we do, we just need it to come into effect. So the thing that I suppose distinguishes between past and prospective surrogacy is the transfer of the embryo. So if you're a parent and you're wondering, where do I fall? It's basically, has the embryo been transferred by the time this legislation is commenced? And so what's happened in Ireland is that we had a commission on assisted human reproduction in 2005, and then nothing really happened until 2014. And then we got our first piece of surrogacy legislation, but we took the surrogacy out of the piece of legislation. And then we came back in 2017 with a general scheme, went through pre-legislative scrutiny in 2019, came up with a bill in 2022. But what happened was, whenever the bill came into effect, or when it came into, I suppose, discussions, it didn't include any provision at all for families who were already created, and it didn't create any provision for international surrogacy. So there was a bit of uproar, including myself. And basically what happened was the Minister for Health, the Minister for Children, and the Minister for Justice all decided to come together and create this international surrogacy committee in our legislature. And so a lot of experts gave evidence over 3 months, and it was very, very good. But then what happened is 100 new pages of the legislation came in January 2024. And so it basically had to be rushed through before the summer session. So we were waiting 10 years and now we have about 6 months to just shove through 100 pages. And so basically it went through the legislative process with a lot of problems and a lot of things that they said, we'll come back to this, we'll come back to this. But it was guillotined. And what that means is it went through the Senate, our Shanad, and basically regardless of the amount of debate that was going to go on, it was passed. And the Senate debates were awful. There was a lot of discussion about how, you know, a child needs a mother and a father, how single men shouldn't be able to have children by themselves, how transgender people shouldn't be able to engage in surrogacy. So it was pretty bad. I wanted to guillotine myself by the end of it. But just to say that it finally got passed with the promise from the Minister for Health that we'll come back to a lot of this stuff. We'll create new legislation in the meantime. So the problem with this is that there's going to be an election, we think, and basically anything that's not passed by the time the election disappears. So we might be back to square one and a lot of problems not fixed. So the other problem is that the Minister for Health has said, well, I'm going to commence the past surrogacy without commencing the prospective. So I'm going to have an interim period where it's a little bit of a no man's land, where I haven't prescribed what will happen in the meantime. I won't tell people how they'll be covered or what standard to follow, but I'll figure that out in the extra legislation that is going to be passed within a month before the next election. So it is truly a bit of a mess, and this is supposed to be the Minister for Health trying to put it out. So so I'll just go into what the law actually says at the minute. So again, not commenced, but for past surrogacy, the standard for domestic is that the surrogate and at least one intending parent, they must be habitually resident in Ireland for 1 year before they entered into the surrogacy agreement. Each party must consent. And what that means for surrogates and children who are over 18, they have to get legal advice before that consent will be valid. So a surrogate must provide identifying information to the National Surrogacy Register. Whenever we've had donor conception laws just come in 2015 and come into effect in 2020, we didn't make donors give any retrospective information. So there's a little bit of a change. So the embryo must have been formed with at least one intending parent's gamete without using the surrogate's gamete and without using the gamete of her husband. And the other must be in the best interest of the child. But as I talk about a lot in this presentation, that's an additional requirement. So you'll all be very familiar with the paramountcy principle, which basically means in any court application, the best interest of the child shall be the paramount consideration. And it's been known to kind of get over certain hurdles when certain criteria hasn't been met. So we don't have that. This is an additional test, but it's a strict tick every single box or you won't get your parental order. So international is basically the same as domestic, except the surrogate must be habitually resident in the relevant surrogacy jurisdiction for 1 year, and the child must have been born in that jurisdiction, but there is at least some discretion there for the judiciary. The surrogate also does not have to provide identifying information for the National Surrogacy Register. So there are no criminal sanctions in past surrogacy, just to say that very clearly, but there are criminal sanctions for prospective surrogacy. I'm just going to stop for a moment, not for any particular reason. It just took me a really long time to figure out how to do this. So if we could all just appreciate it. Thank you. Okay. So I'm talking like a day and a half. So criminal offences. So prospective surrogacy. There's a number of criminal offences. And basically one is engaging in a surrogacy agreement that hasn't been approved by the regulatory authority. The second is knowingly engaging in a non-permitted surrogacy. The next is paying a donor or a surrogate more than reasonable expenses. So we do have a compensated model. Receiving more than reasonable expenses as a donor or a surrogate. Knowingly providing a technical or professional service in a non-permitted surrogacy. So there's two exceptions to that. One is legal advice. So legal practitioners are fine. I wonder who lobbied for that. And then the second thing is medical practitioners. So if someone is already pregnant through a non-permitted surrogacy, medical practitioners are exempt from this criminal offence. So it's also an offence to publish a notice seeking a surrogate or to publish material inducing a person to act as a surrogate. So what constitutes permitted surrogacy? This is really the whole ballgame, because in Ireland, the criminal offence is just not doing every single thing that I'm going to go through. And I should explain that this is a high-level overview. It's a 200-page bill, so there's a huge amount of prescription that you need to meet. Again, there's no paramountcy principle, so if you don't hit every single criteria, you don't get your parental order, and also you're subject to criminal prosecution. So the surrogate, so she must be 25 years of age. She must have had a child before. She can't use her own egg. She can only have had 2 clinical pregnancies before, and she must be habitually resident in the state for 2 years. So internationally, it's in the relevant jurisdiction. Intending parents, they must be 21. They must have a reasonable chance of living to 18, which is madness. They must be habitually resident in Ireland for 2 years, and they must provide a gamete between them. So anyone, for example, any single person who can't produce a gamete, anyone, for example, who has HIV or hepatitis can't use their gamete. This is a separate issue, but a transgender person can't use their own gamete based on how gamete is actually defined in the piece of legislation. But they've told us that they're changing that. So if anyone wants to ask a question, I'll explain. But they must also undergo testing, so genetic screening and that type of thing, which would be standard enough. The surrogacy agreement, so it only lasts 2 years once it's been approved by the regulatory authority. It cannot be commercial. All parties must be known and registered, and there's a consent process. So again, that all sounds kind of straightforward enough, but you just really need to know that it is a very prescribed, particular process by which you do all of these things. So in terms of safeguards, so before you enter into your surrogacy arrangement and you go to the regulatory authority, you have to prove basically that it's a permitted surrogacy. So you have to show that you're going to get AHR counselling, that the surrogate has been physiologically assessed as being suitable to be a surrogate. Every person has to get legal advice, and they have to get it in Ireland and in the country that they travel to for international surrogacy. There's a risk assessment, which has bothered me since the start, because basically someone who is engaging in surrogacy or assisted human reproduction in general, so this covers donor conception as well, they have to prove that they are not a potential significant risk of harm to that child or to any child. And so you can imagine, like, the people who often engage in surrogacy, as we know, are members, I suppose, of the LGBT plus community, and also people who, due to their health status, can't engage, I suppose naturally, I hate that term, but naturally in reproductive conception. So those groups of people are now being put on the spot to prove that they are not a risk of harm to children. So permitted domestic surrogacy, out of the way, this is now international surrogacy. So you must comply with the Irish standards and law of the relevant jurisdiction. So if there's a conflict, you have to follow us in order to get your parentage, in order not to be subject to criminal prosecution. The minister must also green list approved jurisdictions. So it's not just enough that you go to your solicitor and they say, okay, you have to tick all these boxes, and actually this country does that. The minister also has to have sanctioned that jurisdiction as an okay place to go. This is a very strange one, but the AHR provider must give an undertaking that they will not disclose the donor's identifying information to the intending parents. So in Irish policy, I suppose, we're being very, very proactive about identity, although, sorry, there's loads of problems with it, but everything that is being said outwardly is about the child's identity. But yet it requires that even if parents, for example, wanted that openness, had no issue with the secrecy or anything like that, the AHR provider must give an undertaking to our regulatory authority that they won't disclose the information. Commercial agencies are permitted internationally. So again, anything beyond the compensated kind of reimbursement of reasonable expenses is a criminal offence. But the agencies themselves, if they if they charge for their services, they're permitted. Domestically, they're not, and any agency at all, whether for profit or not, they're not allowed. So this is kind of the biggest takeaway from Irish law at the moment, which is that criminal sanctions in Ireland don't arise from exploitation, from duress, from coercion, from undue influence, or from harm. They simply arise from non-compliance. So you are guilty, not guilty, but you can be prosecuted for a criminal offence if your surrogate is 24. Or, for example, she wasn't habitually resident for 2 years, only 1. So I think it's quite severe. Parentage will be refused based on non-compliance, and there's, as I say, there's no paramountcy principle contained within the 2024 Act. So there's no judicial discretion really at all, prospectively, none. So you simply comply with the Act that's there, or no parentage and potential prosecution. So this section, and I'm sorry, because hopefully you can tell from my slides that I just wanted to make this all about fun pictures, but this section I want to bring you through in particular, because this is about extraterritorial effect. So just to take the first part, so a person may be tried in the state for a relevant offence. So if we look at what a relevant offence is, it's basically everything that I've already talked about, but internationally. So say, for example, the publishing, the commercialization, engaging in a non-permitted surrogacy, and engaging in a surrogacy not approved by the regulatory authority. So just to go back, so a person may be tried in the state for those offences. In relation to, I might just go to who can be tried now. So who can be prosecuted? One, straightforward enough, is a person in the state in relation to a place outside the state. The next is a person who's outside the state in relation to a place in the state. This is where it gets a bit dicey. So a person outside the state in relation to a place outside the state, if that person is an Irish citizen or is ordinarily resident in the state, and the act is an offence under the law in the place where the act was committed. So that's kind of, you know, not great, but it's straightforward. At least we know exactly what the law is. The difficulty with this is that if I just bring your attention to subsection 2, subsection 1 applies to an act which, if it had been committed by a person in a place in the state, would constitute a relevant offence. So I know that it's very late in the day. Whenever I first read this, it took me a minute to understand how those two subsections interact with each other. You can see that subsection 1 is subject to subsection 2. So my problem here, I'm just going to make it a little bit easier. So the problem here is an Irish citizen may be prosecuted in Ireland, and I'll just give an example. If they commit an offence in America while they're in America, if both the act is a criminal offence in America, and if the act had been committed by a person in Ireland, it would be an offence. So these are the international offences. They are carbon copies of the domestic offences. So basically what I'm saying is, if the act had been committed by a person in Ireland, it would be an offence. Every act that is a relevant offence has a comparable domestic offence. So basically what that subsection 2 does is it now basically says, okay, sorry, my slides look slightly differently. What it basically means is they set out in subsection 1 to only make it an offence if you were abroad somewhere and you engaged in a surrogacy practice that was also illegal in that jurisdiction. But I believe it's a drafting error. But what subsection 2 is it now negates that, and it now basically says, well, there's a list of all of these offences. They're all offences in Ireland if you do them in Ireland. And so you can be prosecuted outside the state when you are outside the state by the Irish state. So what this means is, just to take an example, so if Mark and John relocated from Ireland to the US, they joined a parents' WhatsApp group and told the group that they were looking to engage in surrogacy, but were having trouble finding a surrogate. They eventually matched with their surrogate in Utah and were able to obtain a pre-birth parental order. They paid their surrogate a lump sum payment. They had no idea the regulatory authority existed, so they didn't make an application for approval. They were not habitually resident in Ireland before the surrogacy agreement was entered into. The surrogate was 24 when she consented. Mark is an Irish citizen, and when his daughter Caroline was born, he wanted her to have an Irish passport. So John is Caroline's genetic father. So already there, that's 2 criminal offences. That's another criminal offence. That's another criminal offence. That's another one. That's another one. So all of these acts, if they were committed by a person in Ireland, would be an offence. And you might just ask, what's the penalty? So anyone who's found guilty of one of these offences, so it can be a fine of up to €50,000 and up to 2 years in prison. So really severe. And that's me. Thanks so much for listening.
Good afternoon, everyone. Thank you to the organizer and to the University of Hong Kong for this incredible opportunity. Thank you to Claire for making it impossible to me to follow her now. But since I'm the last obstacle between you and freedom, I'll try to keep it short. As you might have heard, my parliament passed a new law making surrogacy a universal crime. And that's something we'll address in today's presentation on the Italian perspective on the criminalization of surrogacy. The presentation will be divided into 4 sections. In the first one, we'll try to address the general legal framework, then moving to criminalizing surrogacy, focusing on two subjects, surrogate and intended parents. But if you have any questions regarding the other subjects, there are a few extra slides at the end of the presentation. And then in the third part, we'll look at the impact of the criminalization on legal parenthood and parenting. Finally, trying to make some critical evaluation on the general situation on this topic. So let's start from a translation of the text of the law. The piece of legislation dealing with surrogacy in Italy is Article 12, paragraph 6 of the Italian Assisted Reproduction Act that entered into force in 2004. Which reads that any person who in any form realizes, organizes, or advertises surrogacy shall be liable on conviction to imprisonment for a term of not less than 3 months and not more than 2 years, and to a fine ranging from 600,000 to 1 million euros. The part you can see in bold, it's the one introduced last week, according to which every Italian citizens who committed surrogacy abroad, regardless of whether the practice is legal or illegal there, is punished according to Italian law. So, as you had the chance to see, there is no statutory definition of what surrogacy is. And however, scholars and the case law agrees on the fact that surrogacy is a really broad umbrella term, covering commercial, compensated, altruistic, traditional, and gestational surrogacy, regardless of the gamete donation. And thanks to the new reform, it's now also really clear that it applies to both national and international. However, in an effort to narrow down this really broad umbrella, it is important to notice that surrogacy applies only when artificial reproductive techniques came into practice. Indeed, if the child who's handed over to the intentional parents is the result of a sexual intercourse, that is still a crime, but it's not surrogacy. It is indeed fraud to the law on adoption. The ratio behind this law is, according to the legislator, is defending the dignity of women and fighting the commodification of women's body. In this sense, it's interesting having a look at the wording used by the Court of Cassation in 2022 that described surrogacy as a practice that renders women's body as mere mechanical incubators of other people's embryos. And also, what the legislator suggests is that by criminalizing surrogacy, that will fight the undermining of human relationships, because through surrogacy, new characters are introduced in the reproductive sphere. Therefore, according to the legislator, make it uncertain family relationships. And it's really linked to the last point of this slide, because Italy, as many other jurisdictions, opted for a monistic approach to legal motherhood, therefore making it impossible to legally distinguish between social, genetic, and biological motherhood. Let's move to talking about a bit about the criminalization per se. There are three conducts that are relevant for Italian law, and those are the realization, the organization, and the advertisement of surrogacy. Organizing and advertising are pretty straightforward. Indeed, organizing is more linked to the managerial part of the practice. So having it together, the infrastructure, the tools, and the personnel. Advertising is instead every practice, regardless of whether it's remunerated or not, that make it public, the presence of an offer and a demand of surrogacy practices. So for my own good, that does not apply to me, I think. Then moving to the realization, it just it does change. The meaning does change according to the subject involved in the practice. And it is quite relevant when linked to the fact that surrogacy is a complex procedure that involves several steps. In this sense, neither the case law nor scholars are sure on the perimeter of such practice. Indeed, according to some, the crime is consummated when realizing comes to some relevance with the insemination performed by the medical personnel. According to other, the crime is consummated at childbirth, and according to other again, with the handover of the child. And this comes really, this uncertainty, this legal uncertainty is really important now that that surrogacy became a universal crime, because there are couples that are abroad facing this kind of procedures, and they are not sure whether the crime was consummated before the entry into force, and therefore the universal crime law does not apply to their case or not, and therefore they are not sure whether their vocational exile became permanent or not. And that leads us to talk about the territorial application. I will skip the national part and go directly to the international one. So in the mainstream media, this reform is usually portrayed as the introduction in the Italian jurisdiction of the possibility for Italian citizens to be punished according to Italian law when they commit surrogacy abroad. But that's not true, because that was already a thing before the introduction of the reform. However, there were two limits to this possibility, and those were the fact that the Ministry of Justice needed to file a formal request for the prosecution to start. And in the case law, there was an unanimous consensus on the fact that because of an unbearable degree of uncertainty regarding the double criminality requisite in order to start the prosecution, courts could not punish Italian citizens or whoever for this conduct, because they were not even sure on how to apply the law. What this reform does, it's actually eroding those two limits, making it easier for public prosecutor to start a prosecution against Italian citizens. So the two subjects we are talking about today are the surrogate and the intended parents. Starting with the surrogate is liable to prosecution and punishment for realizing and maybe advertising. Indeed, it is clear that the realization as a conduct applies to the surrogate. However, it is uncertain whether the surrogate respond as a primary or secondary offender. However, from a practical point of view, this distinction is not that relevant, because in principle, Italian courts could apply the same sanction to primary and secondary offender. And it is still debated whether surrogate promoting their willingness to take part in a surrogacy process might fall under the definition of surrogacy for advertisement. What is interesting to notice, however, is that looking at the case law published in legal journals from in the period spanning from 2004 and 2024, prior to the reform, the number of surrogates that are subject to sanction is 0. So the law has never been applied in this sense. Moving to parents, it is clear that when surrogacy is involved, they are liable to prosecution and punishment for realizing such a conduct, with all the uncertainties I mentioned before. However, even after the childbirth and the handover of the child, they might face other criminal charges that are not related. They are de facto related to surrogacy, but are not criminally relevant for surrogacy. And those are providing false information to a public register regarding the individual status, or providing false certificates or false attestation on a birth certificate. Moving to the law in action, we can see how nationally it's like no cases at all. Moving to international cases, the number increases slightly, it's still the same time span. There are no conviction linked to surrogacy as a crime. The other two crimes instead has a slightly higher number of cases related to that. And even to conviction cases. However, it is interesting to notice that those are judgments made by first instance courts that were overruled by the Court of Cassation. So something I found really interesting was saying that in the absence of any kind of statutory law on the status filiationis or legal parenthood of surrogacy-born children, the case law stepped in trying to find a solution, and what they came up with is making a distinction between the genetic parent, the one who provided the sperm, because the sperm always wins, that may apply for a partial recognition of foreign certificate or order attesting the legal parenthood of the child. So there's a direct recognition of the status. And on the other hand, the non-genetic intended parent, the one who did not provide the sperm, needs to apply for adoption in special cases. Regarding adoption in special cases, the Constitutional Court in 2021 urged a reform because this kind of adoption does not fully align with national constitutional and supranational principles. More specifically, the Constitutional Court noticed that adoption in special cases does not provide full parental status to the adoptive parent, and made it impossible to legally recognize any kind of the relationship between the adoptive parent's relative and the adopted child. Moreover, the biological parent's consent was a requisite to start the adoption process, exposing them to the risk of a veto power, of an abused veto power, or to make it impossible for the biological parent to provide such consent in case of death. Moreover, the court noticed that such a procedure, because of the timing involved in the procedure that spanned between 1.5 years and 4 years, does not provide a prompt and effective procedure. The different colors you can see on the slide are linked to the fact that there was a case law intervention in this subject. So the Constitutional Court and the Court of Cassation made some rulings erasing the first two problems. However, the third one, the one related to timing, it's still a problem. The legislature that was urged in 2021 to make a reform in this sense remained silent. The only reform that made is the one linked to the surrogacy as a universal crime. Sorry. I know you were wishing no. But that's the last one, I promise. So, in this sense, at the end of this presentation, what we might argue is that criminalization proved to be ineffective because Italian couples that were still already, they might already in the past face criminal charges for going abroad, asking for the recognition of the parental status they gained in another country. The only risk that this new regulation, this new law introduced is the one to make their procreative exile permanent. The way in which the Italian legal system responded to the ineffectiveness of the criminalization was switching the punitive role to another field of law, that's family law. In this sense, we know that that is the role that naturally is linked to criminal law. However, in this sense, status are used in a punitive way because what they are doing is just delaying the recognition of the parental status by imposing adoption and long procedures. Therefore, all the repressive and preventive role that is generally linked to criminal law is now switched to civil law. In this sense, what they've done is enhancing legal uncertainty regarding legal relationships. If you remind the ratio of the norm, they're going exactly against the ratio of the norm. Moreover, moving to the last point, one question comes to mind, that is the one, given the confidentiality linked on to medical records, we can easily see how even if everyone can rely on such confidentiality, in practice, such confidentiality is irrelevant for some, because it is clear that they relied on surrogacy. Therefore, the ones that are exposed by this reform are people in the LGBTQIA+ community. This norm is want to guarantee the right to dignity to women and fight commodification, but what they are actually doing is adopting a patronizing approach that fights self-determination, and it's particularly painful in a legal system that does not only recognize the right to abortion, but also the right to anonymous birth. Moreover, such an approach might be argued to be hypocritical, if not post-colonial, because they're just thinking about the protection of Italian bodies, and so disregarding completely the bodies of foreign women. And the way they have to protect women's body by threatening with criminal procedure the surrogate, that in their mind is the victim, it's at least an interesting approach. So just last sentence, what the law does is once again protecting and reiterating the monistic family model by binding women and minority group into the darkness. Thank you.